Good morning, ladies and gentlemen. Welcome back to day 2 of the Dilli series CPAR webinar. Day 1 witnessed the Indian Naval Academy virtually housing some of the finest maritime experts in the country. With the opening address by Vice Admiral Puneet Kumar Behel, Commandant, Indian Naval Academy, the webinar picked up the requisite impetus. Then followed the keynote address by the Chief of the Naval Staff himself. A keynote address by former CNS Admiral Arun Prakash, followed by eminent speakers who shared with us a virtual treasure trove of knowledge on the role of sea power in shaping nations. With the changing times and tides, especially in the Indian Ocean region, a discussion on the emerging security challenges seems necessary. As the men and women who are to maintain this security, we must pay close attention to the following session on the theme, CPAR and associated legal aspects, comprising a total of 4 talks by Vice Admiral Puneet Kumar Behel, Vice Admiral G. Ashok Kumar, Rear Admiral Rahul Shankar, Captain Raghavendra Mishra, followed by a question and answer session. To commence the proceedings of session 3 of the webinar, we have a chairperson who aptly embodies the disposition of the phrase, Scholar Warrior. I have the honor of introducing Vice Admiral Anup Singh, Param Vishish Seva Medal, Ati Vishish Seva Medal, Nausena Medal, retired. 4 decades after joining the third course of the Naval Academy, Vice Admiral Anup Singh superannuated on 31st October 2011 as the Commander-in-Chief of the Eastern Naval Command. During his career, he commanded 4 warships, INS Matanga, INS Veer, INS Ranveer, and INS Delhi. In the case of INS Veer in Delhi, he was also the commissioning commanding officer. His last year assignment was that of Flag Officer commanding Western Fleet, during which tenure he led Operation Sukoon, the evacuation of civilians from war-torn Lebanon in July 2006. Senior staff assignments included ACWPNA, ACCP, CI Navy, ACNS Air, DCNS, and DCDI Ops, before taking over as CNC East. A sailing enthusiast from its cadet days, Vice Admiral Anup Singh remained active on the RNCA dinghy and the CBK, later the Enterprise on its induction in India. In 1981, he commissioned the first square-rigged vessel Varuna of the Sea Cadet Corps. The same year, he won the bronze in the Seabird class during the Asian Regatta at Mumbai. In 1989, he skippered the naval yacht Samudra for her Pacific crossing during the round-the-world voyage. After superannuation, he has been pursuing research on geopolitical and maritime issues. He is the visiting faculty at the National Defense College and the Sushma Swaraj Institute for Foreign Services, New Delhi. In the past, he has been associated with various think tanks and institutions in an honorary capacity as member of the Executive Council, IDSA, member, Board for Armed Forces Historical Research, USI, member, Eminent Persons Group on India-Indonesia Relations, Director, Strategic Affairs at the Society for Indian Ocean Studies, Managing Editor of the Journal of Indian Ocean Studies, Visiting Fellow, Vivekananda International Foundation, member, Editorial Boards of Indian Defense Review and India Strategic. He was also the advisor history for the Indian Navy between 2015 and 2018, when he authored Indian Navy's history for 2001 to 10 under the title Blue Waters Ahoy. At this juncture, to formally open our webinar, I would like to give the virtual floor to Vice Admiral Anup Singh. Over to you, sir.
Thank you for that introduction. First of all, I must thank the Commandant and for having invited me to moderate this session. It's always a pleasure to be part of the Dilli seminar, if only because it gladdens our hearts of my ilk, to see midshipmen and cadets doing so well, having imbibed Godspeed in its true sense. I think yesterday's session was very good. It must have, in a manner of speaking, marinated young trainees in this center of excellence insofar as the historical underpinnings and beyond of sea power is concerned. Now that you are in day two, I think it is a rare thing to watch the commandant of the Indian Naval Academy himself presenting a paper on the constitution of the oceans, the UNCLOS, etc., as part of a panel and not addressing the academy in his normal routine from the rostrum. It is indeed very gratifying to note. So before we start the very first paper by the Commandant, let me say a few words on his curriculum vitae. Even though midshipmen and cadets of the INA do not need any introduction on their Commandant, but it is only right for me to read out his CV in order that all those who are virtually present are made aware of his accomplishments and his career. An alumnus of the National Defence Academy, Vice Admiral Puneet Kumar Bahel, was commissioned on 1st July 1984. A graduate of the Defence Services Staff College, Wellington, and the College of Naval Warfare, as it was called at that time in Mumbai, now the Naval War College. He has had a string of appointments ashore and afloat, having earned his spurs on 6 different types of aircraft. He took part in Operation Tasha in the Parkway area and Operation Vijay during the Kargil conflict in 1999. He has served on board various ships for flying and watchkeeping duties. His shore assignments have included both training and important staff jobs at naval headquarters and in commands. His command appointments include those of INS Sujata and of Betwa. 2 important pit stops of his illustrious career that must be mentioned over here were command of the premier naval aviation base, INS Rajali, and as defense advisor at the Indian mission in Tokyo. As a flag officer, he has held important senior level assignments, including that of flag officer commanding Goa Naval Area, flag officer commanding flag officer naval aviation, both at Goa, concurrent, flag officer commanding Maharashtra Naval Area at Mumbai, Chief Staff Officer Training HQ, Southern Naval Command, CI Navy at the DSSC, and as Director General Project Seabird. An accomplishment that cannot be missed in his bio is the award of the Lantine Medal while undergoing the staff course in 1998. Over to you, Commandant.
Thank you, sir, for the very generous introduction. Good morning, the Chair, Admiral Anup Singh, ladies and gentlemen. Over the next 35 minutes or so, I plan to provide a broad overview on the all-important topic of United Nations Convention on the Law of the Sea. The topic is indeed vast and is certainly of utmost importance to the naval and strategic community as it affects our day-to-day operations at sea. We need to develop a fairly good understanding of UNCLOS to ensure that we chart our course to steer in these global commons with clarity, more so in this era of strategic uncertainty and contestation. I intend to cover my talk under the heads as indicated on the slide. Global commons, ladies and gentlemen, like the oceans, space, and cyberspace, present numerous challenges in management due to their unregulated nature. Oceans in particular have been witness to increasing levels of contestation. Oceans are the lifelines for humanity, and all nations owe their development and prosperity to the seas around us. It is relevant to note that around 70% of the Earth's surface is covered with water, and more than 96% of water resource is held in the oceans. 80% of the volume of international trade in goods is carried by the sea, and at any one time, there are more than 30 million people at sea. UNCLOS is an international treaty that establishes a legal framework for the governance, use, and protection of the world's oceans and its resources. Adopted in 1982, UNCLOS is often referred to as the Constitution of the Oceans and is considered one of the most comprehensive and important international agreements. It is also important for us to note that UNCLOS is one of the most widely ratified treaties with 168 signatories, which of course includes the European Union. The fact that most maritime boundaries have been agreed upon by neighboring states and that there have been very few formal disputes is a testimony to the widespread support for UNCLOS by most states. UNCLOS, because of its framework nature, also provides inputs for the development of more detailed regulation by other international bodies such as the United Nations, International Maritime Organization, Food and Agricultural Organization, International Court of Justice, International Labour Organization, and many more. UNCLOS is a living treaty which can change to reflect evolving circumstances based on consensus. It seeks to settle all issues relating to the law of the sea through codification and progressive development of international law. UNCLOS contains 320 articles which are grouped into 17 parts, and it has 9 annexes. These provide guidance for jurisdiction on maritime boundaries, harnessing of marine resources, settlement of disputes, and administration of the convention itself. It also covers aspects pertaining to marine scientific research and provides important definitions. The compulsory nature of seeking dispute settlement by states also reinforces compliance with UNCLOS. Now, coming to historical background and evolution of the laws of the seas, we know that customs and usages practiced among maritime states provided the most significant inputs towards development of the law of the sea. The landmark judgments of the Admiralty Court in England and the treaties concluded between sovereign states also added value to the discussions on UNCLOS. In 1609, Hugo Grotius, a Dutch jurist, published a book on the law of the sea titled Mare Liberum, or the Free Sea. He emphasized on the importance of freedom of the seas and earned the recognition of being the father of international law. In the 17th century, oceans were therefore largely governed by the concept of freedom of the seas. Coastal states then had rights over a narrow band of 3 nautical miles of territorial sea adjacent to their land. Interestingly, this roughly related to the distance that a cannonball could be fired from a shore. All waters beyond this territorial sea were considered international waters, and all states could use them freely. Now, end of World War II and the decline of colonialism witnessed the independence and growth of several Asian and African nations. Further, the rapid growth of science and technology drove the need for exploitation of ocean wealth, including its living and non-living resources. This propelled coastal states to claim larger portions of seas adjacent to their coast for exclusive use, which began to threaten the freedom of the seas. Such claims and counterclaims forced international opinion to seek clarity on the sovereign rights of coastal states vis-à-vis freedom of navigation and legitimate usage of the seas by other nations. After World War II, therefore, the United Nations General Assembly set up an international law commission for the purpose of codification of the law of the sea. This resulted in the preparation of 4 draft conventions in 1949, which were formally adopted at the first UN conference in Law of the Sea, or the UNCLOS I, in the year 1958. The participating nations, however, could not reach an agreement on the breadth of the territorial sea in view of conflicting claims on the delimitation ranging from 3 to 12 nautical miles. The issue of exclusive fishery limits could also not be resolved. The second UN conference, or the UNCLOS II, was held in 1960, and this again failed to reach an agreement on the same two critical issues, mainly due to strong opposition from the developing countries. The third conference on the UNCLOS II witnessed a series of negotiations in various meetings from 1973 to 1982. UNCLOS was adopted in 1982 and formally entered into force in November 1994. The important non-signatories include Kazakhstan, Peru, Turkey, Turkmenistan, Uzbekistan, and of course, the United States. It is assumed that the non-signatories are still bound by many of the provisions of UNCLOS, as they are now generally accepted as reflecting customary international law. I will now cover some of the key features of UNCLOS for the larger understanding of the audience. The territorial sea extends up to 12 nautical miles from the baseline of the coastal state. Within this zone, the coastal states exercise sovereignty and have full control over the waters, airspace, seabed, and the natural resources therein. Foreign vessels, including warships, are allowed innocent passage through these waters as long as they do not pose a threat to the coastal state's security. Contiguous zone is the zone that extends a further 12 nautical miles beyond the territorial sea. Here, the coastal state has the right to prevent and punish infringement of fiscal, immigration, sanitary, and customs laws which have occurred within its territory and territorial sea. Please note this. Exclusive economic zone extends up to 200 nautical miles from the baseline. Within this zone, coastal states have sovereign rights over the exploration and exploitation of natural resources, including the living and the non-living resources. The coastal states also exercise jurisdiction over marine scientific research and environmental protection. All other states have freedom of navigation and overflight in the EEZ, as well as the freedom to lay submarine cables and pipelines. Coming to continental shelf, it comprises of the seabed and subsoil adjacent to the coastal states, where they have sovereign rights for the exploring and exploitation of resources. The shelf can extend up to 200 nautical miles from the shore. UNCLOS allows states to claim an extended continental shelf beyond their EEZ up to a maximum distance of 350 nautical miles from their baselines, provided they can demonstrate that their continental shelf is a natural prolongation of the landmass. The high seas, ladies and gentlemen, includes all parts of the sea that are not included in the EEZ, territorial sea, internal or archipelagic waters of a state. All states enjoy traditional freedoms of navigation, overflight, scientific research, and fishing in the high seas. States are obliged to cooperate with other states in adopting measures to manage and conserve living resources. No part of the high seas can be subject to claims of sovereignty. Coming to the area, it is the seabed beyond continental shelf and is governed by the principle of common heritage of mankind. The International Seabed Authority was established under UNCLOS in 1994 to provide for the equitable sharing of financial and other economic benefits derived from the activities in the area. International states, on the other hand, are narrow bodies of water that connect two large bodies of water and are used for international navigation. Passage through these states is governed by specific rules, such as the transit passage for ships and overflight rights for the aircraft. States bordering the states can regulate navigational and other aspects of the passage. Archipelagic states are the states that are made up of groups of closely related islands and interconnecting waters. They have sovereignty over a sea area enclosed by straight baselines drawn between the outermost points of the islands. These waters between the islands are declared archipelagic waters. States may establish sea lanes and air routes in these waters where all other states enjoy the right of archipelagic passage through such designated sea lanes. UNCLOS also establishes a legal framework for pollution prevention. It calls for prevention, reduction, and control of pollution from land-based activities, ships, and through marine dumping. It establishes rules for environmental impact assessments and requires states to cooperate in addressing transboundary environmental issues. States are liable for damage caused by violation of the international obligations to combat such pollution. States are bound to promote the development and transfer of marine technology on fair and reasonable terms and conditions, of course, with proper regard for all legitimate interests. Now, let's look at maritime dispute settlement. Maritime disputes can be resolved via judicial and non-judicial means as stipulated in UNCLOS. Part 15 of UNCLOS provides states with 4 avenues to settle their disputes through the International Tribunal for the Law of the Sea, or ICLOS for short, the International Court of Justice, or ICJ, an arbitral tribunal constituted in accordance with Annexure 7 of UNCLOS, and, of course, a special arbitral tribunal constituted in accordance with Annexure 8 of UNCLOS for one or more of the specified categories of disputes, such as fisheries and marine pollution, etc. Conciliation is also available, and submission to it would, of course, be compulsory. In terms of institutions for global governance, UNCLOS created the Hamburg-based International Tribunal for the Law of the Sea, that is the ICLOS, the Kingston, Jamaica headquartered International Seabed Authority, or ISA, and the Commission on the Limits of the Continental Shelf, the CLCS, based at UN headquarters at New York. ICLOS is the primary judicial body for disputes related to the interpretation and application of the Convention, while CLCS is mandated to scientifically determine the maritime boundaries of states related to the continental shelf. The ISA is designated to oversee exploitation of the resources of the deep sea area. Now, having seen the key attributes and theoretical strengths of UNCLOS, it would also be prudent to examine its limitations in a realistic manner. Now, while UNCLOS provides a legal framework and is widely adopted, its enforcement mechanism, ladies and gentlemen, are limited. It relies on the voluntary compliance by states. There are, therefore, challenges in holding states accountable for violations, particularly in cases where powerful states like China, US, and Russia are involved. This is a weak point indeed for all international law and is even more challenging in the maritime domain. Further, Law of the Sea insists upon 2 cardinal principles of freedom of the high seas and the exclusive jurisdiction of the flag state. On the high seas, which is the area covering most of the world's oceans, only the flag state has jurisdiction over vessels, except in very limited circumstances. In practice, however, the extensive use of flags of convenience has led to a jurisdictional vacuum on the high seas. Now, let me explain this. Flags of convenience entail registering of ships with states other than the home states. This is done because the states of registry have limited domestic regulation in areas such as pollution, labor protection, and taxation, etc. Further, the states that registered flags of conveniences have little enforcement capacity. This has significant implications for maritime security. Examples of states allowing flags of convenience include Panama, Liberia, and the Marshall Islands, which together represent the top gross tonnage in such type of registration. Another weakness of UNCLOS lies in the area of large number of breaches of law like piracy, drug and gun running, and maritime terrorism activities, etc., carried out by non-state actors. In such cases, UNCLOS and its related treaties rely on the direct enforcement by individual states, depending on where the breach took place. Many states do not have domestic legislation aligned with UNCLOS to cater for these contingencies, unfortunately. In December 22, Indian Parliament, ladies and gentlemen, passed the Maritime Anti-Piracy Bill, which will apply beyond the limits of the Indian EEZ, and it aligns with UNCLOS. In accordance with the law, act of piracy will be punishable with imprisonment for life. Now, varied interpretations of UNCLOS by states who support their acts of omission and commission and some gaps in understanding also result in conflicting claims. As an example, UNCLOS does not clarify the scope of military activities permitted by other states in EEZ of some coastal states. Some maritime states, like including US and other Western powers, support unfettered military activity in EEZ of other coastal states without permission of the latter. Conversely, some coastal states, including China, Iran, and Peru, etc., object to military activity in the EEZ by expressing concern for their national security and resource sovereignty. So while UNCLOS imposes no restriction on military activities within EEZ, there is, however, an increasing tendency among coastal states to restrict the use of their EEZ by warships and aircraft of other states, especially those that they perceive are carrying out intelligence gathering activities. Denial of access to the EEZ can lead to possible confrontation. Additionally, Article 56, that deals with rights, jurisdiction, and duties of coastal state in the EEZ, gives the coastal state the right to fix installations and structures within their EEZ. These include artificial islands, and they could be so designed and placed in such a way so as to cripple the NAV rights of states with whom the concerned coastal states may not be having cordial relations. Another potential cause of dispute arises from the right of coastal state to adopt non-discriminatory rules and standards against vessel source pollution and to enforce these when necessary. The passage of potential polluters such as nuclear-powered vessels, vessels carrying hazardous cargoes, and ammunition ships through the EEZs of some of the coastal states may in time be jeopardized by the coastal states. Now, coming to the sovereign rights in the continental shelf, Article 77 of the UNCLOS stipulates rights of the coastal state over the continental shelf. Coastal states should, however, not undertake activities which result in any unjustifiable interference with navigation or rights and freedoms of other states. However, UNCLOS does not list down specific parameters to define the scope of unjustifiable interference. Further, UNCLOS does not lay any embargo in utilization of these installations or artificial islands for some form of military purpose. Additionally, coastal states can invite third parties for exploring the continental shelf, which may attract criticism from an adjoining coastal state who may not share healthy bilateral relationship with either of these partnering states. As an example, India and China looked headed for a diplomatic row in 2011 after China asked countries to refrain from oil exploration in the maritime areas offered by Vietnam in South China Sea. India had then dismissed Beijing's territorial claim over the sea. ONGC Videsh, as we know, ladies and gentlemen, has been in Vietnam for quite some time in offshore oil and natural gas exploration. Now, the other aspect is that UNCLOS has provided ambiguous conditions and maritime zonal entitlements to certain geographical features like rocks and islands. As per UNCLOS, islands can have baselines for all maritime zones. Rocks, on the other hand, irrespective of their size and large extent of spread, have not been provided with maritime zonal entitlements beyond the territorial sea. Habitability has been a criteria for assigning maritime entitlements. UNCLOS, however, places no restriction in the matter of islands, even if the island is unable to sustain human habitation or economic life. Further, conditions to be satisfied for human habitability have not been defined. This ambiguity can create controversy as man-made efforts may convert an inhabitable rock to a region which can sustain human habitation, although for a very limited time. Powerful states like China have already done so deliberately, and this has aggravated disputes on entitlements in South China Sea. Prominent maritime disputes which stem from the anomaly in Article 123 of UNCLOS include those pertaining to the Spratly and Paracel Islands, Scarborough Shoal, and the Okinotori coral reef of Japan. Now, coming to the aspect of upholding freedom of navigation, those states are expected to exercise freedom of navigation in the seas with reasonable regard to the interests of coastal states. Implementation of extended air defense identification zones and maritime exclusion zones does violate the concept of freedom of navigation and overflight. The justification advanced by states for creation of such zones is national security or self-defense. Therefore, while the need of advance warning in case of developing hostile situations is understood, the aspect of enforcement of separate zones which are not recognized by UNCLOS needs far more collective deliberation to find a way ahead. Issue of nav area warnings and notices to air mariners in case of planned operations and firings is the more accepted norm. Coming to fishing rights in EEZ, the fishing regime within EEZ has been the matter of frequent disputes, especially between states with overlapping EEZ and also between coastal and landlocked states. Article 69 and 70 of UNCLOS provide that landlocked and geographically disadvantaged states have the right to participate in the exploitation on an equitable basis. However, in reality, UNCLOS created a serious ambiguity in not defining the specific extent of this EEZ, which the coastal state is duty-bound to concede for marine resource exploitation by the landlocked nations. Of the world's approximately 206 states, 46 states have no seacoast at all. Now, ladies and gentlemen, UNCLOS was adopted in 1982, and since then, new challenges have emerged, causing gaps. The intergovernment discussions on the BBNJ have also been ongoing since 2017, and broad agreement has been reached on salient issues in March 23. This instrument will need to be ratified by at least 60 UN states before it can enter into force, which may take years to fructify. BBNJ aims at cooperation on conservation and sustenance initiatives beyond EEZ, and it seeks an integrated approach to ocean management in the high seas. The issue of enacting legislation on challenges of emerging technologies like the maritime autonomous vehicles is also being discussed. One school of thought is that the application of the principle of equivalence to them would ensure that the use of these newer technologies upholds the core principles of UNCLOS and therefore, as a corollary, uphold their right of innocent passage. There are, of course, complexities in this approach, given the fact that such vehicles would not have crew on board, could undertake diverse range of military missions, including surveillance, and being software-centric, they could be open to cybersecurity threats. Another example of where state agreement on the interpretation of UNCLOS is urgently needed is the question of refixing of baselines and associated maritime entitlements in response to rising sea levels. As global warming leads to rising seas, several nations, including those in the Pacific, fear their islands could eventually be flooded, shrinking their EEZs and their rights, therefore, to fishing and seabed resources. Therefore, they are trying to lock in existing zones now. A 2018 resolution by the International Law Association supported the vulnerable islands, arguing that any maritime zones determined under UNCLOS should not require to be recalculated if the sea level changes and affects the geographical reality of the coastline. Then there is the problem of plastic pollution, including in the marine environment, and this is another challenge affecting the oceans today. While UNCLOS addresses land-based sources of pollution, the United Nations Environment Assembly is working on finalizing a legal instrument on plastic pollution by the end of next year. UNCLOS, therefore, ladies and gentlemen, touches on various aspects of what is now encompassed in the 2030 Agenda for Sustainable Development Goals. It calls for the negotiation and coordination of additional instruments through other competent organizations, including ISA, CLCS, and ITLOS, that were directly established by UNCLOS. One other important competent organization is, of course, the IMO, headquartered in London, which is tasked with developing rules and standards on shipping. The purpose of IMO is to facilitate cooperation in the field of governmental regulation and practices related to shipping engaged in international trade. It also encourages adoption of the highest standards of maritime safety, efficiency of navigation, and prevention and control of marine pollution from ships. It does this through international conventions that it updates regularly. Now, therefore, having seen UNCLOS, it is also important to go through some of the important case studies. Now, one case study pertaining to China and South China Sea is revealing. There have been occasions where states have refused to engage in arbitration process or follow the resultant judgment or award. In 2013, Philippines brought a case against China over its activities in South China Sea. The case was heard by an arbitral tribunal under Annex 7 of UNCLOS, and in 2016, it ruled in favor of Philippines. China, despite being a signatory to UNCLOS, did not engage with the proceedings and has not accepted the ruling. The dispute pertained to an imaginary maritime boundary called the 9-dash line, which was unilaterally declared by China in 1947. UNCLOS had ruled that China has no legal authority to use the 9-dash line as the maritime boundary and make historical claims over the East and South China Sea. However, UNCLOS has had success stories too. The case in point are the settlements of the long outstanding maritime boundary delimitations in the Bay of Bengal between Bangladesh and Myanmar by the International Tribunal on the Law of Sea in March 2012 and between India and Bangladesh by the Permanent Court of Arbitration in July 2014. Notably, all three parties willingly embraced the verdict of the concerned international courts. Countries like India, given their own backdrop of ensuring peaceful resolution of issues under UNCLOS and who have stakes in the region, have therefore called for free, open, inclusive, and prosperous Indo-Pacific. Now let us look at US and its relation with UNCLOS. US, ladies and gentlemen, was among the nations that participated in UNCLOS 3 and the subsequent negotiations for modification to the treaty till UNCLOS came into force in 1994. Although US recognizes UNCLOS as a codification of customary international law, it has not ratified it. Basic disagreement stems from Part 11 of the Convention concerning deep seabed mining of valuable metals. It claims that the treaty is unfavorable to American economic and security interests. US also argued that the International Seabed Authority established under UNCLOS might become unwieldy and an expensive bureaucratic organization. Now coming to the US Freedom of Navigation Operations, or FONOPS for short, the US FONOPS program was instituted in 1979 to bolster its national interest in protecting maritime rights and freedoms of the sea. The US has maintained that as long as some countries continue to assert limits on the maritime rights and freedoms that exceed the coastal state authority reflected in customary international law, it will continue to challenge such unlawful claims. Article 31 of the Vienna Convention provides for interpretation of a treaty based on the subsequent practice of the parties. Accordingly, in the event of a particular maritime claim of a nation going unchallenged over a significant period of time, that maritime claim then, despite it being an excess or deviation from the treaty, would result in it becoming an accepted interpretation of the treaty. Therefore, based on the said principle, it appears that US regularly challenges these excessive maritime claims by way of freedom of navigation operations. As we know, US has repeatedly undertaken FONOPs in South China Sea. Now let us look at another interesting case study, and this one relates to the diplomatic row on state sovereignty between India and Italy. India and Italy were involved in a decade-long complex legal tussle on the issue of state sovereignty, UNCLOS and domestic laws. This incident happened on 15 February 2012, consequent to the killing of 2 Indian fishermen and arrest of 2 Italian Marines who were on board an Italian-flagged oil tanker named Enrica Lexi. The vessel was transiting off the coast of Kerala through the Indian contiguous zone, and the 2 Marines on duty at that time shot at the fishing boat St. Anthony, suspecting it to be undertaking a piracy attack. After a prolonged international and national legal process, the Supreme Court of India quashed the legal proceedings and transferred the case of the 2 Marines to Italy for trial there. A compensation of rupees 10 crores was also paid by Italy to the victims. Now, in conclusion, ladies and gentlemen, it needs to be borne in mind that UNCLOS draws its strength from customary international laws developed over centuries of seafaring traditions. Further, UNCLOS is rooted in years of debate, deliberations, and negotiations through 3 conferences over the past 80 years. It has involved unimaginable amounts of consensus building and expert scrutiny. It has therefore rightfully gained wide acceptance and has also played a key role in facilitating good order and discipline to the proceedings at sea. While UNCLOS has its weaknesses, efforts are continuously being made to address these. Compliance with these legal regimes is crucial for maintaining stability, promoting cooperation, and avoiding conflicts at sea. While UNCLOS is fairly settled on many questions of governance, contemporary challenges such as the management of strategic ocean spaces like South China Sea are prompting a debate over further refinements in the treaty. Encouraging cooperation amongst academia, states, regional organizations, and international bodies can facilitate information sharing, improving maritime surveillance capabilities, and coordinated actions to address non-compliance. Further, states should reinforce their national legal frameworks to align with UNCLOS provisions and establish, therefore, effective monitoring and enforcement mechanisms. It is therefore important to note that the legacy of UNCLOS endures well and truly into the 21st century, presenting opportunities for international cooperation to challenges that necessitate innovative solutions. India, ladies and gentlemen, is a key player in the maritime domain, is well positioned to contribute to the ongoing discourse and shape the trajectory of UNCLOS as it navigates the geopolitical challenges and complexities of the seas in the contemporary world. With this, I have finished. Thank you. Jai Hind, Samnovaram.
Thank you very much, Admiral. That was a comprehensive dose of the constitution of the oceans, and you gave a very good account of some of the case studies. Now we move on to the second speaker of today's session 3, which is Captain Raghavendra Mishra, who will, let me first introduce him. Commissioned on 1st January 1989, Captain Mishra is a naval aviator with ASW as specialization. An MPhil in Defense and Strategic Studies, he has held a variety of appointments, mostly afloat, besides 2 tenures each at Naval Headquarters and as directing staff at the Defense Services Staff College. Amongst command assignments, he has skippered INAS 330 or the Harpoons and an MCMB. Unlike many of us who cannot lift our heads out of files, he has been a researcher throughout his career, studying military history, geostrategic and doctrinal trends, international security, operational art, and the law of the sea in particular. He has authored around 50 articles which have been published in reputed national and international journals. In addition, he has co-edited 2 books on maritime security issues in the IOR and contributed chapters to a number of edited volumes with oceanic and strategic themes. Though he swallowed the anchor recently, almost a year ago. And he's seriously pursuing his PhD from Madras University on the topical of all subjects, the South China Sea. Over to you, Raghu.
Thank you very much, Chair. A very good morning to the entire audience, especially to the young and vibrant trainees at the Indian Naval Academy. At the outset, let me thank the Commandant and the organizers of this event for affording me an opportunity to express my views on a subject of relevance. And I also thank the Commandant of Defense Services Staff College, who has extended me the video conferencing facilities so that I'm able to participate, hopefully seamlessly, without vagaries of cyberspace intruding into or interrupting my participation. Now, the topic which has been given to me is to provide an overview of the cause of armed conflict, the San Remo Manual, and the limitations and the enablers with some interesting case studies. Now, the time allocated to me is about 35 minutes, and I discussed it with Chair that it may not be possible to discuss any case study in reasonable detail. So what I have decided is that I will stick to the essentials and the fundamental tenets of laws of armed conflict and the San Remo Manual, and try and provide examples in most of the key issues so that for the ease of understanding and add value to theoretical and conceptual issues. I've divided my talk broadly into three sections. First, of course, is a lot about what is law, what are the fundamentals of legal theory. The second part, of course, deals with the laws of armed conflict. And here I will also talk about the general and universal humanitarian considerations, because laws of armed conflict cannot be discussed without these, because they exist as associated entities, and one cannot be discussed without the other. And the last part will be a broad overview of San Remo Manual and what effect it has had and the way forward. And lastly, a few takeaways. Now, whenever we talk about laws and war, you hear a very common refrain: all is fair in love and war. Now, I will not dwell upon the affairs of the heart, but let me talk about that this particular proposition is entirely misplaced. It seems to signify that there are no limits to the ends and means and methods and weapons used when somebody or militaries are engaged in any conflict. It is not so. And let me take the definition of a more contemporary, by a more contemporary author on what is an armed conflict. And I'll use a collection of phrases which I have extracted from Samuel Huntington's famous book on civil military relations, which is Soldier and the State. And what he says is an armed conflict or war, as it was classically known in the earlier times, is systematic application of organized violence for political purposes. So let me develop on these three phrases. So the first word that I would like to concentrate is violence. The profession of arms is a special profession. It is the only instrument of state that is inherently violent. And if I take all the niceties away from, the definition, etc., it is about causing physical harm and damage on the population and its facilities. And this is a particular factor that we must not forget in the humdrum of everyday activities. Now let me concentrate on or come about to the other two key words, which are organized and systematic. Basically, these two words signify that there are some norms of professional conduct, and there are some organizational, structural, and international restrictions and constraints on use of force. These restraints and constraints actually force all militaries to do a few things that they must and desist them or restricts them from doing a few things. Now, these constraints and restraints exist at organizational level. That is, the Navy itself has certain policies on how do we go about applying the force. There are certain national legislations like the Navy Act of 1957 and the Constitution of India, which binds the navies and the other arms of the service, other arms and services, as to how do we go about applying the deployment of force. And then, of course, there are international constraints and restrictions. At the national and at the strategic level, most of these constraints and restraints come. And we are duty bound to abide by these on every occasion that we envisage the use of force. Now, before I go on to the laws of armed conflict, dwell a little bit about what is law, what is expected. Laws are a set of norms that are supposed to regulate the human conduct in a specified field. Just to give an example, the Motor Vehicles Act is expected to control the behavior of all users who use any means of transportation, including the pedestrians. All laws, whether they're based at the municipal, national, federal, national level, are founded on two key principles. They appear paradoxical at the first glance, but this has to be understood for us to understand, or to have a better understand, or have to better grasp of what is the letter and spirit of all legal instruments. The first principle is of predictability. Predictability in interpretation of what is right and what is wrong. And the second principle is flexibility in application. That means the enforcement and adherence to law will only be done depending upon the circumstances of the case. And let me try and explain these two principles by citing one of the articles of law of the Navy Act 1957. Sleeping on watch is punishable by death or such other punishment as is hereinafter mentioned. That is what this particular article states in the Navy Act. Now, the predictability part is that sleeping on watch is an offense. But the punishment, the maximum punishment that can be awarded is death, and it cannot be awarded as a matter of fact or matter of course, or is not the default punishment. It is only the maximum punishment. This maximum punishment can only be awarded when the ship or the particular organization, and it also allows award of a lesser punishment depending upon the circumstances of the case. But that is what general law is. The purpose of the law is to encourage adherence to civilized norms of behavior. And secondly, is also to administer justice and authority, in that a person is awarded equitable punishment based on his gross violations. It is never about equity, and that's why the phrase, serving of just deserts. Which brings us now to what is international law. International law is a body of law where at least one party to of the legal of that law or that body of law is international in character. And it can further be divided into two categories. The first category is what is known as the international, where nation states and formal organizations are the primary participants. To give an example, how India conducts its international relations with neighboring countries like Sri Lanka, Nepal, or even those in extended abroad like United States, United Kingdom, Russia, etc., comes under the rubric of international law. And what do I mean by formal organizations? Formal organizations like United Nations, its subsidiary bodies, European Union, NATO, SAARC, IMF, World Bank. These are considered as formal organizations. The private international law is the part of national law which governs the conduct of private international entities like Amazon India, etc. Now, the laws of armed conflict and the associated humanitarian considerations fall under the ambit of public international law. Public international law as a study has only come about 3 odd centuries ago and is still a relatively new field of legal jurisprudence and evolving very rapidly at least in contemporary times. The next point that we need to understand is that there is not one source of international law. There are multiple sources, and these are defined in Article 38 of the Statute of Justice. All parties to the United Nations are also subject to jurisprudence of International Court of Justice, with certain exceptions. So the sources of international law are divided into primary and subsidiary sources of law. The primary sources of law are three. The first of these is known as international treaties and conventions. Admiral Puneet Vail just spoke to us about UNCLOS. UNCLOS is considered as a convention, so it is a treaty. The other terminology is used for to describe this is also known as treaty law, codified law, written law, because this particular body of law is in formal written form. Now, how do we find out what is a treaty or what is a convention? The sole condition for any formal document to become or assume the status of a treaty or a convention is that it must impose a legal binding obligation on conduct of the involved parties. What it means is that I have 5 options available. The treaty will force me to adopt one particular one of them. And it really does not matter by what name it is known as. A similar agreement is a treaty between India and Pakistan after 1971 conflict. NATO is a treaty organization, as the name itself suggests. Warsaw Pact was a formal treaty. So it really does not matter. It is the condition of legal binding obligation that makes a formal document treaty. The second source of international law is customary, or what we call as international custom. International custom is a practice almost universally accepted by a large part of the Community of Nations and practiced over a long period of time. Where do we find customary international humanitarian? International Committee of Red Cross and Red Crescent is the repository of all customary laws related to laws of armed conflict and the associated humanitarian considerations. So if one goes to their website, just types customary articles, subject-wise, they have made a database of what is customary law. And like health. Many of the treaty or the conventions or the written laws have actually evolved from customary practices. The third source of international law is law of civilization, which actually means that as long as a nation has a well-developed system of legal justice and it is multi-tier, it is acceptable as a source of law. Just to give an example, the division of use of waters, which were use of rivers, which were also national boundaries, was most well developed in Western Europe till about 19th century. Thereon, the laws, national laws, federal and international, as well as national, amongst the American continent, that is North and the South American continents, have become the point of reference on this subject. So these are the three primary sources of international law. Now, none of them is higher in precedence over the other. In fact, in certain cases, the national laws have taken precedence over international treaties and conventions. It all depends upon the contents of the case. Now, there are two other subsidiary sources of international law. The subsidiary sources of international law, their role is to provide interpretative stability to the existing to the primary sources. And these are also two in number. The first one being the decisions and awards of the international tribunals and courts. Now, the judgment itself is only applicable to the embattled parties. However, the logic that has been used by a court or a tribunal to expand upon a certain point on which there is some controversy becomes a general position for further application. To give you an example, the principle of delimiting EZ and continental shelf in case of an overlap is equity or equitable distribution. Now, the principle or the doctrinal aspect was defined as equidistant relevant circumstances, and a three-step method was adopted in the case involving maritime delimitation in Ukraine and Kenya in the Sea of Azov. And this principle has now become the norm for further delimitations in cases of similar intent. Like it was this particular process adopted in both the Bay of Bengal arbitrations involving Bangladesh in India and Bangladesh in Myanmar. So the last or the second source of international source is the writings of eminent jurists. Like, as was mentioned, the freedom of the seas doctrine was articulated by Hugo Grotius. The only qualifying part is that these writings must be well researched and of course balanced. Now, having seen what is law, what is international law, its sources, let us now come back and let us come down to the first, I would say, the important or the key factor of today's talk, which is the fundamental principles of laws of conflict. But before that, let us look at what do we mean by a military object or a military target, and this is actually defined in Article 42 additional protocol, and it says that military objects are those which by their nature, location, function, and their destruction, functional, I would say, dislocation, and their capture will offer a significant military advantage in the prevailing circumstances. So this is what a target is. So the functionality, temporal dimension, aims, whether military intent, etc. define what target is. Now, the important point to note here is that it does not say that it has to be only military in character. As long as it aids a particular military function, it can be targeted, valid, it becomes a valid target. So, a power station supplying electricity to a military installation is a valid target. A bridge or an airport being used to military purposes is a valid military target. So it's the functionality and its relation to the military needs of a particular belligerent that makes it a valid military target. Coming back to the fundamental concepts. Now the laws of armed conflict coexist with I would say, generally acceptable universal humanitarian principles. And these are two in number as far as military aspects are concerned, and these are also two as far as humanitarian aspects are concerned. And these are like two opposing scales which require very careful and deliberate balancing. The military aspects are, the first of these is what we call as military necessity, or some people call it validity. This basically determines when do we use force, what event demands use of force, and where if this event happens, is the force of is the use of force mandated. The second military aspect is what is called as the principle of proportionality. It basically tells us that the force, the quantum of force that we use or that has to be used has to be proportional to the threat imposed. To give an example, if the adversary misses us by 2 inches and fires a bullet, it does not mean that we have to fire a bullet that misses him by 2 inches. No, that's not the way that we determine proportionality. We have to, our response has to be dictated by what was the military intent of the adversary. If it's his intent, if the adversary's intent was a harm, including death, and the means and methods employed will be determined by what is our assessment. Now, this is a subjective assessment, and the means and methods employed have to be proportional to what threat we have assessed ourselves to be subjected to. So these are the military aspects, that is of, I would say, military necessity and military proportionality. Now let me come to the humanitarian aspects. The first principle of humanitarian aspects is of distinction. Whilst I talked about what is a target, it is also a universal basic principle that military attacks are only to be directed against military objects and combatants. Civilians and non-combatants are not to be subject of deliberate attacks. That is what the law says. At any point of time, we have to use our weapon carefully and even the method in that we do not cause injuries to civilians and non-combatants. And there is no compromise on this particular principle. The second principle of humanitarian nature is what we call as prevention of superfluous injury and undue suffering. And this particular principle applies even when we are using weapons against military personnel. So our means, that means the weapons, and the method of attack has to be such that it does not cause undue physical harm, injury to people or to the property that is the subject of military attack. To give an example, biological weapons and chemical weapons are prohibited because they cause undue suffering and superfluous injuries. There are weapons which are conditionally, like napalm. Napalm is a mixture of petroleum and industrial jelly and makes a colloidal solution, and it sticks and burns. Its use is permitted against organized formations, but its use against combatants in open is prohibited. And to give you a further insight, any weapon or method of attack that cannot abide by the humanitarian considerations of distinction and prevention of superfluous and what I call undue suffering becomes illegal and prohibited. It does not become illegal and prohibited just by its nature. It needs that once you use it under conditions of planned use and it is operated by a person who has training and it is not able to abide by the conditions, the weapon becomes prohibited and illegal. There's certain other examples like expanding bullets, which are also known as dum-dum bullets. These were soft-nosed and bullets, so they tumble in the air, they enter one side and cause expand and fragment within the body of the targeted personnel and cause excessive injuries. So these have become prohibited over a period of time. Having seen all these four considerations, let me re-emphasize that neither military needs can take priority over humanitarian considerations. Neither humanitarian conditions should be able to override the military needs. So a very careful and deliberate balance is required whenever a use of force is anticipated. So the first question that might come is that this body of law is known as laws of armed conflict. Does it apply in isolated cases? Does it apply in less than war conditions? The answer is yes. And this is actually ensured by what we call as rules of engagement. Rules of engagement determine permissiveness or freedom with which the military instrument can be applied. And this permissiveness is far lesser in stable conditions, and it becomes more and more permissive as we move from stable to crisis to combat situation. Do these military and humanitarian conditions apply to internal armed conflicts? The answer is yes. And this is rooted in case law and actually derives its strength from the judgment that was passed by the International Criminal Tribunal for Yugoslavia when they indicted the first Serbian militant leader, Duško Tadić, in 1997. And thereafter, it has become almost a universal law. The important point to understand here is many countries, including India, do not accept this particular interpretation of international law. That means laws of conflict and conditions apply to internal. We see all acts of militants, extremism, terrorism as criminal acts. And our position is that our domestic law is adequate enough to treat them. We do not need to record the formal status of a combatant and become subject to international considerations. So this is where I've given you that where there is a difference between national and international positions. And the position similar to India has been taken by a large number of countries, totaling almost about 70 odd of them. Having seen what is military theory, having seen largely what laws of armed conflict and humanitarian consideration and the fundamental principles, let me come to San Remo manual. There are a lot of San Remo manuals, and the San Remo manual that you're talking about is, full title of it is San Remo Manual on International Law applicable to international law applicable to armed conflict at sea. This was adopted in June of 1994 by an institution known as International Institute of Humanitarian Law. A series of meetings were held from 1988, and finally this document is a very concise document that is here. What is the need of this amendment? What is the status of this particular, I would say, the document, and what purpose? And now, there were many reasons why this particular document was needed. First, of course, was a very long temporal span and a diverse, I would say, body of legal instruments that impacted upon naval operations. Let me give a small, let's say, interesting mix of these. The earliest body of international law that still applies to naval operations is 1899 Hague. The next is 1907 Hague Convention. Then there is 1930 provisions on submarine warfare as part of Treaty of London. Then there is Convention on Protection of Cultural Property of 1954. There are four Geneva Conventions from 1949 and two additional protocols from 1977. Then there are Environmental Modification, Chemical Weapons Convention, and Biological Convention, roughly from 1970s to 1993. So you look at it, this is not a comprehensive list. But if you look at it, there are almost, I would say, 30 odd international legal treaties and conventions that apply to naval operations, spreading over 100 years. And in these 100 years, the means and method of warfare have evolved. And these were impacted by certain seminal cardinal events as well. First, of course, was the evolution of 1982 Laws of the Sea Convention, which was a very comprehensive regime of ocean governance quite different from what was existing or what was obtained from 1958 deliberations. We had also seen the Gulf War I conflict, where weapons with extended ranges, great precision, and I would say uh, enhanced lethality were used extensively during this conflict. So to normalize all this and provide a very concise restatement of formal, that is written, as well as customary international law in new environmental realities of a new regime of ocean governance and military realities, a document was needed. So that is what this particular San Remo manual is aimed to address. The deliberations was attended by a mix of serving and retired practitioners, legal experts, diplomats, academia, scholars, both as informal and individual capacities. India was represented by then Commander, later Commodore P.K. Goyal, in the capacity of an observer. The status of this manual is that it is non-legal binding. And despite such non-formal nature, it has had profound impact on countries, and nations have evolved their operational philosophies at sea. That said, most nations also have certain disagreements on certain points as contained. The purpose, whether it has served this purpose or not, I would say that the results have been mixed. In many ways, it has enhanced the debate on codification and restatement or revision of many of the existing legal bodies. And in some cases, it has brought about serious dissensions as well. This particular document is just 420 odd pages and is divided into the first part is, of course, deals with general provisions. Second part deals with in what all topics or in what all areas and in geographical regions will this San Remo manual be applicable. The third, fourth, and the fifth part are actually operational. That means laws related to targeting, laws related to operational issues, laws related to protected and exempt vessels. So these are the 6 laws. Now there are some strengths of this San Remo manual. It has addressed or included some of the customary problems. But to say that it has included all of them is also not true. It has left out some important customary national law, especially related to belligerents. It was quite comprehensive in the time that it was formulated. But obviously it has not yet. There have been developments which have overtaken what is contained in this manual, especially with regard to the evolution of unmanned systems, AI, machine learning, and especially it does not address what is going to be one of the key issues of future, which is lethal autonomous weapon systems. So there is a need for us, which is read that this manual needs revision. However, an attempt was made and it has failed because of serious differences between interests. I'll leave them that. This particular, some of the shortcomings of these have been also addressed by a very recent document, which came about in 2023 and is titled as Newport Manual on Naval Warfare. And one of the Indian naval officers, Captain Gurpreet Khurana, a veteran, a newly minted veteran, also participated and represented India in the formulation of this manual. Let me come to one of the concepts which has been addressed in some manner by the San Remo manual, which is exclusion zones. Exclusion zones are not new. They have existed from, I would say, they were used as defensive zones in first time in 1904 by the Japanese concept. Then slowly became graduated as conditional and then free fire zones during the 2 world wars. And in the exact terminology, they were used during the 1982 Afghan conflict, where both sides promulgated, prohibited the entry of certain Military assets extended it to restricting the entry of any asset in a particular geography. It was quite successful during 1982 conflict, not by design but by default because it was in a remote geography. However, when it was attempted during the 1980, the later stages of 1980 or 88 Iran-Iraq conflict, it met with mixed success, and similar was the result during the first and the second Gulf War. Now, in my opinion, the exclusion zone as a tool is not is a useful tool. It has to be used with careful deliberation and serves operational purpose. How to promulgate it, etc., is a matter of operational duty. Now, San Remo manual does not have an exclusion zone in the exact terminology, but it allows establishment of security zones as an exceptional measure by belligerent, and it gives specific as to how to go about doing it, etc., etc., which is very close to what we are supposed to do when we impose a blockade. The important point is it has included customary provisions where a naval commander or one of the naval commanders can regulate the movement of neutral vessels and aircraft in the immediate area of operations. So in that sense, it gives us lends some legitimacy to this concept. Now let me come to the final takeaways. Somehow there is some amount of distrust and mistrust I see as far as law is concerned amongst practitioners, because we see it as it binds our hands. I have tried to explain that law is not a limiter. Law is an enabler and a balancer. As long as we understand that there is a limit of professional behavior that is required from people who are in the business of this noble profession of arms, and good understanding of fundamental principles and critical specifics will stand us in good stead. And I say this because it is important for good conduct to maintain the repute of your organization. To give an example, the My Lai massacre by the US forces against innocent villagers in Vietnam shook conscience of not only the world but brought bad name to the military for a long time to come. And it's also incumbent as commanders and leaders that we understand law, because you can be punished for it. Let me cite another example, what is known as Yamashita Doctrine. General Yamashita was commanding the Japanese forces in Philippines during the Second World War. And when the Allies attacked, the Japanese forces went on a rampage, engaged in widespread killing, rape, pillage, plunder. So when General Yamashita was brought to trial at Tokyo, he said that I never gave these orders. And he was right. But that did not absolve him. Not only are we not supposed to give good orders, but we are actually supposed to supervise that the conduct of our subordinates is always legal and legitimate. So, in the end, law is not something to be afraid of. It gives us many options, and we should not get carried away by moral consideration. With that, I finished. Thank you very much for your patient listening, and I'll be open to any questions that you may have. Thank you very much, sir. I finished.
Thank you, Raghu. Once again, a very comprehensive coverage of the subject, which is not very commonly debated and not clearly understood by those who haven't gone through the ICRC's documents or the treatise given in San Remo manual. Now we shall go to the Q&A for these two papers, for these two panelists. So the House is open to questions. Any questions?
Good morning to all the speakers. My name is Cadet Saksham Thakre of the third term. My question to the Commandant INA is, Sir, what challenges does the UN face when it comes to ensuring compliance with UNCLOS in regions where conflicting territorial claims or disputes have arisen? And how have they addressed these challenges?
Cadet Thakre, you are very bold in having asked the first question to your commandant. Over to the commandant.
So, Thakre, the aspect is that if you look at it from the larger perspective, the UN has already done his bit in terms of ensuring that the UNCLOS 3 came into force, and 168 members are parties to this treaty. And thereafter, once you become a party to this treaty, there is a aspect of compliance to all stipulations which are there in that enactment. And therefore, to a very large extent, this is facilitated. If you look at the larger aspects of UN itself, I mean, it is always very important. They look at from the point of view of peaceful resolution of all issues, disputes before they become conflict. The idea is that you should be able to resolve and nip the issues in the bud. And therefore, they encourage to a very large extent that all aspects are first resolved peacefully. If it is, if they are not able to resolve peacefully, then you resolve issues diplomatically through the regional-based agreements. And thereafter, you go into arbitration. And of course, you can go into these ICLOS insofar as UNCLOS is concerned, and the ICJ, the International Court of Justice. The advantage of arbitration really is that it gives you more flexibility, and also you can choose as to who are the people you want to go for arbitration. So these are the agreements which are already there. Now, I presume if you are taking the argument a little forward and you want to bring out the aspect that, let us say that this dispute is not resolved and it then runs into a conflict. Well, then, of course, the UN has, again, certain ways to handle it. That is that they have, the chapter 6, 7, and 8, in which you can, based on the consent of parties. Firstly, it is important that all parties have to give the consent so that UN can depute peacekeeping force to resolve an issue in case it has gone to a dispute. So, whereas the peacekeeping operations involve the deputing of these troops to that area so that the the conflict, does not escalate beyond a certain point and cause undue harm, injury, and killing of the people of both the sides. And the other aspect is enforcement. That situation rarely, if ever, comes where you find that the conflict has gone to such level that it has gone into unmanageable proportions. And therefore, UN, again, through the all these are done through the Security Council mandate. You cannot do it any other way. And thereafter, under Chapter 7, then they can do peace enforcement. And then there is, of course, a Chapter 8, which looks at, again, regional agreements to resolve the issues once the conflict has taken place. But by and large, the situation of conflict should not arise. That is the aim. But there are cases where parties do tend to preempt the aspect of running it through the jurisdiction of the UNCLOS. And in 2014 also, if I remember correctly, the Chinese and the Vietnamese had raised the issue to the level of UN Secretary General. At that point in time, the Secretary General's office had said that they will be happy to use their office in good faith to ensure that the negotiations are peaceful and the issues are resolved. So therefore, directly the UN does not do anything in this. It is the UNCLOS which through its offices only it has got approved. So I hope what I've said in some ways answers your question.
Thank you.
Next question.
Good morning to the chair and all speakers. I am Cadet Saurabh Kumar from 36 NOC Extended Force. My question to Captain Raghvendra Mishra is, Sir, how does the San Remo manual remain relevant and adaptable in addressing the legal and ethical challenges posed by advanced and evolving modes of warfare in the 21st century, including a growing dependence on drones and autonomous unmanned weapon system. Would the San Remo manual be required to be modified to cater for these developments?
Raghu, all yours.
Thank you, Cadet Saurav, for the question. Now, I can say, uh, there's a fundamental principle which states that any weapon, as long as it cannot be used to destroy and cause a superfluous injury or undue suffering.
Sorry to interrupt, Raghu. There is a little audio feedback. I think there may be some speaker of the Star College system which is close to the mic.
So there's none which is open here. I can assure you.
Yeah, now it is perfect. Now you are all right.
Thank you, Cadet Saurav, for that question. Like I covered, there is a general and a universal legal provision that any weapon system or any military system or a method of attack that does not or cannot comply with the principles, humanitarian principles of distinction, superfluous injury, and undue suffering becomes illegal or prohibited. That said, you're right, and I covered it during my talk that San Remo manual was came about or evolved in 1994. Now, obviously, at that point of time, the unmanned dimension had not assumed that kind of relevance or operational importance as it is today. So it does not address that. And I did bring about that, yes, there is a requirement to revise the San Remo manual. Unfortunately, the recent attempt to revise it has run into serious dissensions, and the differences between the interest groups, which are actually between the practitioners who look at a more positivist to the legal experts who want very specific rules, etc. Then amongst the realists and the people who emphasize the one humanitarian aspects to the people who think that the military needs must assume importance, the revision attempt has unfortunately failed. So that's where we stand. So I hope I have answered your question. And the Moon manual does not address it. We need to revise it. The attempt has failed.
Thank you, Raghu.
Thank you.
Next question.
Good morning to the chair and all speakers. I am Cadet Vikas Singh of the third term, and my question to the Commandant INA is: India, being a member of Quad, has a significant footprint in the Indian Ocean region. In the event of disputes or incidents related to freedom of navigation operations, what mechanisms and legal frameworks can India rely on to contribute towards a peaceful and lawful resolution?
Okay, first of all, FONOPS is an American term. The expansion of FONOPS, freedom of navigation operations, does not fall under the purview of UNCLOS, but it is perfectly all right for your question to be over to Admiral.
So as the chair has brought out, FONOPS is a unilateral process with the US follows, and I had dilated on why they do it, so that the wrong practice in their perception should not, therefore, under the Geneva Convention, become a stipulation which then they accept as customary law. So insofar as the FONOPS is concerned, I would like to remind the audience that we also had a case of, we have had cases of US FONOPS, but not so regularly. And I think the last one took place, if I'm not mistaken, in April 2021. And that is the time the US ship had sailed through, I think, almost about 130 nautical miles in vicinity of the Lakshadweep Islands. And that is the time our relationship was really looking very good. And somehow it took the entire strategic community by surprise as to why US has done it. India had very strongly protested. But I think the larger issue is that even in India, insofar as India is concerned, in its exclusive economic zone, it earlier had the 1976 Territorial Sea Exclusive Economic Zone and in the MZI Act. And therefore, before India had signed, these stipulations were existing. And India had that then indicated, even while signing, that in case of any military maneuvers or any firing military exercises, etc., which take place in our EEZ, that is not something which we will accept without our consent. So that is how, insofar as India's stand is concerned, even when they signed, they had brought this up. But yes, the UNCLOS does not look at it from, therefore, this ambiguity which I covered during the part of my talk. Now, therefore, the aspect of FONOPS is something which we cannot hoist as a part of the Quad. So to say that India should then align and, so that would perhaps not be a very prudent course of action. All what we can do as part of the Quad is to ensure that the stipulations under UNCLOS need to be adhered to by all parties, and wherever there is a difference of opinion, then that has to go through all these steps legally. And India has also, as when they have chaired some meetings in UN Security Council, also has said and brought out that peaceful resolution to all issues on sea need to be undertaken, and even UNCLOS needs to be adhered to. So that's the contribution India has done even in UN Security Council when they had the chair till recently, I think 22, 23. And so these are the ways, but in terms of sort of pushing the aspect of FONOPS, that I don't think is a correct way to do it, because that does not have universal approval and is not permitted by law in legal terms.
Thank you, sir.
Absolutely correct. As the Commandant has explained, first of all, Quad and UNCLOS have no relationship as such insofar as guidelines of Constitution of the Oceans is concerned. But to the larger question of, as the Commandant explained during his presentation as well as now in answer to your question, insofar as FONOPS in trying to tell various states that certain declarations made by them after ratification of the treaty, for example, we did it in 95 or 96, as was just explained by the Commandant, that warships that try and cross are either individually or as a group in carrying out such military maneuvers which involve disposal of ammunition or firing of ammunition or surveys, etc., are not welcome. And therefore, there is a clear hint in that declaration that prior notification equivalent to permission or words to that effect will have to be obtained. Now, the United States has time and again said that we carry out FONOPS since the 80s. Particularly through EEZs of those states which have such declarations like China, and they include India without saying it verbally or passing it down formally. And we have asked them a counter question: how about ratifying the UNCLOS? And of course, they almost came close to ratifying it about 10 years ago when Hillary Clinton, as Secretary of State, followed by the then Secretary for Defense, had said that it is time for the United States to finally ratify the UNCLOS, because we are supposed to be the foremost nation in trying to keep the seas peaceful and tranquil. And they fell short by one vote in the Senate, which was 67 out of 100 votes. So these are their own problems. And strictly speaking, FONOPS is not codified in any law, any international law. Thank you. We have come to the end of the Q&A session by time. Over to control for the sake of declaration of tea, which you guys are lucky to have in person. We people will have it virtually.
Thank you very much, sir. While I'm thanking you, I also know that you are coming back for the remaining part of the session. And With this, may we request you to kindly log off as convenient, and thereafter the control will set it up again for the rest part of the session. Thank you very much.
Thank you. Thank you.
Ladies and gentlemen, we are halfway through session 3, and it is now time to take a break. We will see you on the other side at 1110 hours. Ladies and gentlemen, welcome back after a short break. I request the chairperson to introduce the next speaker and continue with the session.
Thank you. I hope all of you have enjoyed the tea break, as did I without the camera and the mic. We move on to the next panelist, and we are fortunate to have amongst us Vice Admiral G. Ashok Kumar, who is the first National Maritime Security Coordinator, NMSC, appointed to this most awaited assignment by the Navy and the nation, which happened sometime after he hung up his uniform as the Indian Navy's Vice Chief. An alumnus of the National Defense Academy, he was commissioned on 1st July 1982. He commanded iron ships Dilli and Ranveer. His important shore stints included being head of training team at the Defense Services Staff College, India's defense advisor at the High Commission of India, Singapore, and CSO Ops at the Western Naval Command. On promotion to flag rank, he held important assignments, including those of Flag Officer Sea Training, Chief of Staff, Southern Naval Command, Flag Officer Maharashtra and Gujarat Naval Area, and Commandant NDA, Deputy Chief of Naval Staff, and finally, as the Vice Chief of Naval Staff. His contributions to the Indian Navy have been immense, which include an array of operational and administrative initiatives, such as conceptualizing the now famous concept of mission-based deployments by iron ships, implementing the transition cycle, and introduction of BTech at NDA, to name a few. He is a graduate of the Defense Staff College, Wellington, the Army Higher Command Course, MAO, and the Expeditionary Warfare Course in USA. As India's first NMSC, Admiral Ashok Kumar has been instrumental in enhancing multi-agency and center-state coordination towards enhanced maritime security. By the way, the first time that the Indian Navy had put up a proposal for a National Maritime Security Coordinator or a Maritime Security Advisor was in 2005, when a presentation was made to the so-called Committee of Secretaries chaired by the then Cabinet Secretary. So it's taken a long time, but there are durustai, as we say, and he is doing a great job insofar as not just pursuing the Navy's aims in ensuring maritime security in our areas of interest in waters around India, but also the national objective of ensuring that peace prevails around the peninsula and the island territories. He will be speaking on piracy, armed robbery, terrorism, IUU, fishing, and legal aspects pertaining to it. In other words, not traditional threats as much as the non-traditional challenges that are facing the new world order ever since the end of the Cold War. Over to you.
Thank you very much, sir, for the kind introduction. Commandant, am I audible? I hope I am audible. I'll just continue. If there's a problem, please revert back to me. Thank you, sir, for your kind introduction. Commandant, INA, faculty and staff, cadets, ladies and gentlemen. Good morning to you all. Now, following up on the presentation by the Commandant and Captain Raghavendra Mishra, topics related to maritime law, I shall now cover the topic allotted to me, which is written on the slide: piracy, armed robbery, terrorism from the sea, IUU fishing, and legal aspects, including case studies and way forward. Okay, I'll mainly concentrate on the legal aspects of it. Okay. In the last 2 days, at least twice, you heard the name of Hugo Grotius. I heard Admiral Arun Prakash mention it yesterday, and the Commandant INA mention it today. In fact, Mare Liberum is a book written by Hugo Grotius. The first name that I've written there on the slide, Santa Catarina. In fact, the slide looks blank because I just removed the photograph that I put up because of, I think, the size of the file. But Santa Catarina was a Portuguese ship which was anchored in the waters of Singapore, and Dutch, who were then occupying Indonesia, captured that ship. And so the Portuguese argued that no, you cannot do it because the waters belong to me. So Hugo Grotius, one of the jurists who argued the case for the Dutch, said that waters cannot be owned by anybody. Thereby came the concept of Mare Liberum. In fact, he wrote a book in 1604. Santa Catarina incident was on 1603. So this started the whole concept of seas being global commons as to how nobody can own them. And then Admiral Arun Prakash also mentioned the 3-mile limit, which is basically the range of shore-based cannons, and which kind of belonged for security reasons to the coastal state. And this continued for a long time. There was also an argument between Mare Liberum and Mare Closum, which is the open seas versus the closed sea. But this concept continued till the early 20th century. And in the early 20th century, there was this widespread desire by nations to expand their national claims into the sea. Because, there were plenty of resources that were to be found in the sea, and the coastal states were very keen that they were allotted areas in order to exploit these resources. So the UNCLOS discussion started. I know the Commandant covered it in greater detail. I will just touch upon it. It was in fact the third United Nations Conference on the Loss of the Seas, which started in 1974, culminated in the United Nations Convention on the Loss of the Sea in 1982. In 1982. Now, this UNCLOS came into force in 1994, and India ratified it in 1995. Now, despite this having come in and the areas having been divided, that means the coastline to 1 miles was territorial sea. From the coastline to 24 was your zone, up to 200 was the exclusive economic zone. So, despite all these, it had to be a compromise between Mare Liberum and state control. So, therefore, you will find that there was considerable amount of leeway given in order to ensure Mare Liberum into the sea. So, as you moved away from the coast, you find that the laws that were applicable became more and more lax. Now, this had repercussions on maritime law. And the need was. I hope I'm audible. I can hear some noise coming back to me, but I hope. Okay, and then, yeah, thank you. Now let me just briefly touch upon the continued evolution of maritime law. After UNCLOS came into being, there was 1988 SUA Convention and Protocol. I mean, the full name is written there: Convention for Suppression of Unlawful Acts Against Safety of Marine Navigation, and a Protocol for Suppression of Unlawful Acts safety of its platform, which are located in the continental shelf. This came into being in 1988, and this entered into force on 1st of March 1992. This, of course, was ratified by India too in 1999. I will talk about that slightly later. In 2005, there was a protocol to the SPA Act which was introduced, and this was essentially a consequence of the 9/11 attacks that happened. So this covered basically it was to address various acts of terror. Okay, let me now take some time in describing to you how maritime laws evolved in India. I know that the Commandant spoke about the Maritime Zones of India Act 1976. In fact, it's got a long name. It's actually colloquially called the Maritime Zones of India Act, but the actual name is not. This came about in 1976. This actually laid down that up to 12 nautical miles from our coast is territorial waters, category zone, and exclusive economic zone, and what kind of rights we enjoy in these waters. In 1978, the Coast Guard came into being, and the Coast Guard Act was passed. I mean, this was basically because in late 60s there was increased smuggling along the Indian coast, and there was a concern that the Navy, that our primary aim of preparing for war was kind of being sabotaged by our increased involvement in law enforcement activities. So there was a Rustomji committee which was set up and which recommended constitution of a Coast Guard. So the Coast Guard came into being in 1978. The next thing that happened was in 1981. There were two things that happened. One was that the Maritime Zones of India, regulations for fishing foreign vessels in India's maritime zones got passed. So this essentially prevented foreign fishing vessels from fishing in Indian EEZ unless they had an Indian government license. That was one. And the second was that because we had found oil in 1974, any crimes that happened, say, on an oil platform could not be tried with IPC and CRPC because they extended only to territorial waters. So this was the extension of applicability of IPC 1860 and the CRPC 1973 covered the whole of Indian EEZ. This again was passed in 81. Now, if you look at the above line on the slide, that is the international laws, and below the line is the Indian laws. So, in 1982, of course, UNCLOS was passed. Why I mentioned this here is because you will notice that the Maritime Zones of India Act actually preceded the UNCLOS 1982 by 6 years, and therefore there were some, I will not call it lacunae, but something that was authorized as per UNCLOS, which is not, we did not find mention in the Maritime Zones of India Act. I'll cover that a little later. We also, in 1985, passed the NDPS Act, which is basically Narcotics and Drugs Act, 1985. And the line above, in 1988, I had mentioned about the SPA Convention and Protocol. And so I said, had ratified in 1999 and passed our own SPA Act 2002, in the year 2002. The protocol I had mentioned was passed in 2005. Actually, this has not been ratified by India because there is a feeling that it just goes against, non-signatories of NPT. So that is one of the reasons why we did not sign it. In 2016, one coastal police station for state was nominated by a gazette for trying crimes. Otherwise, earlier there was only one each on each coast. Yellowgate Police Station in Mumbai and one in Calcutta, which could where maritime crimes could be filed. This was going to be too complicated, and I'll give you a case as to why this became an issue much later. But 2016, this is Coast Guard was legally empowered for every law applicable in the maritime domain. This was a gazette notification in December 2019. So the Coast Guard now is legally empowered. As to what the Navy is legally empowered for, I'll cover a little later. In 2022, we passed the Maritime Anti-Piracy Act. That came into being because every international law, unless and until is supported by a domestic law, the prosecution becomes a little difficult. Okay, next, let me go on to the topic, which is piracy. Now, piracy, as you're aware, is as old as seafaring itself. In fact, there is a scene in Southeast Asia that the first ever seagoing boat was manufactured to go catch fish, and the second one, which was manufactured to go rob the fish that the first boat had caught. So, piracy is as old as that. In fact, if you look at history, many kingdoms actually supported piracy. And there were enough kingdoms. In fact, even in the Indian coast, a lot of kingdoms actually supported them because pirates required some funding. And once they came back, they also had to sell their wares that they had pirated. So as a result, there was some state sponsorship of piracy, or the kingdom sponsorship of piracy. Oh, okay. So now, piracy and the birth of navies are linked. In fact, if you were to read some books, like one of the books I can tell you is The Price of Admiralty. In the introductory page, it says as to how the navy was born in order to protect trade, to prevent piratical acts. Now, therefore, if you look at UNCLOS, for example, when UNCLOS 1982 came into being, it really has a special attention towards piracy. And that's a lot of good for. Yeah, I'm just moving it away so that there's no disturbance in my speech. Okay. So UNCLOS has a special attention towards piracy. Now, if you look at Article 100, it says all states shall cooperate to the fullest possible extent in the repression of piracy on the high seas or in any other place outside the jurisdiction of any state. This is quite standard, or shall cooperate to the fullest possible extent. I think applies to almost all kinds of threats that they are out there at sea. But if you look at Article 101, it also stipulates the geographical limits of piracy. It says on the high seas and in areas beyond national jurisdiction. It excludes only territorial waters. So, if you see, high seas are actually beyond the EEZ, but and in areas beyond national jurisdiction, just beyond the territorial waters. So, anything which is within territorial waters is called the armed robbery. And I must also tell you here that the armed robbery is not a legal definition, but it is used for document both by the UN, IMO, and all the countries these days. It is also formally designed by IMO, for instance, much later. So this is used widely now. Article 105. Now this provides universal jurisdiction for piracy. Now it says, I mean, if you were to just read through the text, it says on the high seas or in any place outside the jurisdiction of any state. I'm sorry for spelling mistake. Every state may seize a pirate ship or aircraft, or a ship or aircraft taken by piracy and under the control of pirates, and arrest the persons and seize the property on board. So this gives the leeway for any navy or any coast guard or any governmental ship actually to seize a ship which is even beyond your jurisdiction. Now, if you look at Article 1101, this stipulates specific situations in projects and other duly authorized government missions can actually board, even under suspicions of the following act. And you will find again piracy is one of them. Slave trade is another. One more that you find is nationality. This I will mention a little later too. This is a very important one. Okay, now if you look at India and piracy, as I said, there is a need for domestic laws to be passed in order for our own, jurisdictional capability or prosecution to be taken forward. So therefore, this Maritime Anti-Piracy Act 2022 being passed is a major step. And if you look at that act, it says that for piracy committed in high seas. Now, immediately when the act was promulgated, there were a lot of calls checking out as to why have we left out REZ, because the understanding, the UN, in fact, the UNCLOS definition of high seas is beyond the Maritime Anti-Piracy that India passed defines high seas, And it says it includes EEZ and other waters beyond jurisdiction of any state. That is what the meaning of high seas is. And there is also an explanation following the which says EEZ means the EEZ of any other state, including the EEZ of India. Okay, therefore, our Anti-Piracy Act 22 applies from our territorial waters to the limits of some other. Okay, now there are a lot of measures which are in place towards countering piracy. One point that you got to keep in mind is that all non-traditional threats to maritime security are transnational in nature, and they also have a huge impact on economy. Because like for instance, for India, 95% of our trade is through the maritime route. Therefore, if there is a piratical attack, it directly hits on our economy. Now, you also find that because traffic tends to concentrate in choke points, piracy is mainly concentrated at choke points. Gulf of Aden is one example. Malacca Strait onto our eastern side is another example. If you look at Malacca Strait, piracy operations have been undertaken by several countries: Indonesia, Malaysia, Singapore. Now they've got the sea patrols by these three, and there is also an ice in the skies, air patrol that Thailand has also joined. So all four countries do Malacca Strait anti-piracy ops. In 2005, there was also RECAP which was set up, which is Regional Cooperations Against Armed Piracy, with an information sharing center at Singapore. In fact, currently the boss of RECAP is the ex-Director General of the Indian Coast Guard, who is there stationed at Singapore. Now there are 14 countries who are members of the RECAP, and India is one of them. So this is just a collaborative effort towards addressing piracy. Now, Indian Navy, probably you all are aware, has been undertaking a Gulf of Aden deployment since October of 2008. And this anti-piracy deployment has gone on since October 2008 till today without a break, and with ships being relieved on task there. We now also have, of course, earlier we were independent deployers. We did not collaborate with anybody except for being a part of the team, sharing our escort schedules and so on and so forth. But now we have an Indian Naval Liaison Officer at the Combined Maritime Forces at Bahrain, who basically takes care of all the combined task forces in that area, which have got various roles, including anti-piracy operations. And CTF 150, which is for anti-piracy, Indian Navy is now an associated member of the CTF 150. Now, just one to mention about a case study. In 2011, there was, in 2018, piracy went up. The pirates started moving further and further east from the Somali coast. And there was a time when they had fetched up in the islands of Lakshadweep and Nicobar. And so, in fact, there were piratical attacks that were happening right off our island. So, there was a need to address this. In fact, our standard operating procedures at that point in time only mentioned that we should just take away the piracy, let the boat go back to shore. But we found that this would just, they would just go back, embark more piracy figures and come right back here. So an off-island watch was launched to the west of the islands. It was a joint talk with the Indian Navy and the Coast Guard, and it was hugely successful. About 119 pirates, I recall, were arrested and brought to, brought to Cochin. And Cochin said, no, we can't take this case because this is beyond our jurisdiction. I come back to this point of why police stations in every state were nominated to try maritime crimes. So they had to be embarked onto a Coast Guard ship thereafter and brought to Mumbai, where the case was filed in Elevate Police Station. They remained with us nearly till 2017. And we couldn't try because our Anti-Maritime Piracy Act had not been passed, and we promptly handed them over back to the elders of Somalia for them to try the case. Okay, I mentioned about impact of economy, so this is just to indicate to you the number of ships that carry trade for us and to India through these choke points. You look at these numbers. Like if you look at Gulf of Aden, there's 1,800 and 2,000. That is from and to India. And if you look at Malacca Strait on the east, It is 3,000 ships from India and 4,302. So you can imagine if this were to be stopped or hindered by piracy as to what the result of the Indian economy would be. Okay, let me just move on quickly to terrorism. Now, there are numerous examples of terrorism at and from the sea. I recall some of the speakers earlier mentioned about USS Cole in October 2000. I think it was Admiral Pawar who mentioned 12th of October. And the French oil tanker Lindbergh, both of them were slammed into by small boats, with explosive laden on them, came and slammed into these two ships, causing heavy damage. Of course, it was again 9/11 which triggered thought of, will tankers be used as floating bombs? Will they just enter a harbor, throw themselves up and close the harbor? And a lot of other initiatives like the Container Security Initiative and the Proliferation Security Initiative all came into being immediately post 9/11. Insofar as India is concerned, 26/11 2008 actually happens to be a watershed event for us. There were a number of things that happened. In fact, the whole coastal security architecture came into being. Lot of technological and administrative improvements were made to the coastal security structure, and we are where we are. But I will go into the details of that. But all I would want to cover is the legal aspects of this. Terrorism as a phrase is not mentioned in UNCLOS, and you quite often hear that terrorism has not even been defined. And an acceptable definition has not been developed for this word terrorism because somebody or the other will put a spoke into it. It was in 1988, as I mentioned, SUA Convention and Protocol was passed. This was for safety of navigation, marine navigation, and for safety of fishing, fish platforms in your continental shelf. But it was the 2005 protocol that actually addressed some of these terrorism concerns. This was again triggered by 9/11, and that covered, carriage of weapons of mass destruction or transportation of fugitives, including terrorists. Now, I must mention here that I told you about India not having signed up to this 2005 protocol. Okay, and the third one is IUU fishing, which was given to me, which is illegal, unreported, and unregulated fishing. Now, this is not merely fishing in someone else's EEZ, which is illegal, but even unreported and unregulated, just to ensure that the fishing is sustainable. Therefore, even our own fishing boat within our own EEZ can be unreported and unregulated. So we need to be cautious of that. Okay, IUU accounts for 26 million tons of catch annually. I think again it was Admiral Pawar who mentioned out of 5 fish served on your table, one of them is an IUU. So that's the severity of this, with increasingly depleting stocks of fish in the sea. But there are adequate provisions in UNCLOS. If you just type fishing, the number of hits in the UNCLOS document is quite high. And there is also an agreement on state measures to prevent, deter, and eliminate fishing. Now, this is called the PSMA. And this is basically to ensure that the signatories to the PSMA do not allow fishing boats of anybody, any other country as well, to come and upload their catch in your harbors. So that is that port safe measure. So this was placed for ratification in November 2009, and it came into force in June 2016. The other initiative to eliminate IUU fishing is the regional fisheries management organizations. This one actually is a voluntary. I think this is these RFMOs are the FAO of the United Nations, and yet this is just voluntary. So if you sign up to the RFMO, you just ensure that you abide by the rules that the RFMO stipulates. There are only 2 of them in the Indian Ocean region, COFA, which is the Southern Indian Ocean, and the IOTC, which is the Indian Ocean Tuna Commission. Now, the Southern Indian Ocean, obviously, is Southern Indian Ocean. It does not cover Bay of Bengal and Arabian Sea. IOTC does cover, but the problem is it has got limited stocks or limited varieties of fish that it addresses. And the constraints, as I mentioned, once it is voluntary, there is no tough measures to ensure that somebody is violating it. You know, like for example, there are distant fishing fleets of a particular country which are deployed here in hundreds, where you find vast majority of them are actually not registered with the IOCs. So now the excuse can always be that I don't catch tuna or not do I catch any fish which is on the list of IOTC. But you know, that is one of the constraints that I think harms our effort towards addressing IUU. Now, what are the maritime laws in India to counter this? If you look at Schedule 7 of the Constitution, fisheries and fishing beyond territorial waters is in the Union list, Serial 56, but fishing within territorial waters is a state list. So therefore, if it is territorial waters, the license which is issued for fishermen to fish is by the states. Now, each state therefore has a State Marine Fisheries Regulation Act, and the center has a central act. Now, I also spoke to you about the MZI, Regulation of Fishing by Foreign Vessels Act 1981. Now, in this act, the Coast Guard is empowered in the very act. The Navy also got empowered under the MZI Regulation of Fishing by Foreign Vessels Act in 1982 by a separate gazette notification. Okay. Now, the Indian Marine Fisheries Bill 21 is something which is now being, progressed, but some of it's not progressed as smoothly as one would have expected. Okay, let me just conclude. I've got another 10 minutes, so I will conclude to give you some basics. One is that I think as naval officers operating out at sea, we need to know the rule book. Now, this is a weak area. Maritime law is not a strong subject with most of us, not with our lawyers actually. So this is something that we need to put in efforts to know it. We need to know who is legally empowered under what law, because quite often we take on tasks which we are not even legally empowered. So, as I mentioned, in December 2019, there was a gazette notification which empowered the Coast Guard as being legally empowered for all the laws of the maritime domain. So, anything that you say that India has passed, the Coast Guard is legally empowered. Whereas the Navy is only empowered for 3 different things. 1, piracy under the Maritime Anti-Piracy Act 22. The second, illegal fishing by foreign vessels in our MZI under MZI Regulation for Fishing by Foreign Vessels Act 1981 by a separate gazette which was passed in 1982, and then certain administrative provisions which are under Merchant Shipping Act, and very normal ones, nothing to write home about. Now, the point that I'm trying to make here is that we need to be conscious of this fact that the security responsibilities allotted to various forces need to be commensurate to their legal authority. So we cannot take on a task for which we are not legally empowered. So this is one thing that we all need to keep in mind. Now, there is a need for us to amend the MZI Act. Why is that? If you look at the India's map that I've shown you here, you've got these lines. The blue line which is closest to the coast is what is called the baseline. The red line next to the blue line is the limit of your territorial waters, which is 12 nautical miles from the baseline. If you look at the last line that you see, that is the limits of the EEZ. Now, why amend the MZI Act? Because I had mentioned when the MZI Act came into being in 1976, that preceded the UNCLOS by 6 years. UNCLOS caters for countries to adopt straight baselines. Now, if you look at the Gulf of Kutch, I don't know whether my mouse moves on the slide, but here is the Gulf of Kutch, here is the Gulf of Kambar, or look at the Lakshadweep and Minicoy Islands. Earlier when the MZI Act got passed, your maritime zones of India started from the coastline, and the coastline was the base. Whereas the UNCLOS allowed you to create baseline. So you could actually draw a line closing the mouth of Gulf of Kutch, or closing the mouth of Gulf of Kambar, or closing the entire Lakshadweep and Minicoy, and similarly the Andamans. So suddenly your baseline had moved away from the coastline in some areas, and this is not catered for in the MZI Act, and that created something called the internal waters. If you between the pipeline and the coastline in the Gulf of Kutch and Gulf of Kambas, those waters are called the internal waters. That is mentioned in the UNCLOS, defined in the UNCLOS, does not find mention in the FDI Act. So this is one requirement that we need to address immediately. In fact, we have worked on the amendment with huge help from the and it is now being progressed by the MEA to pass to amend the FDI Act. Okay, some of the others are address gaps in RFMOs. I mentioned about how IOT comes, but there is a lack of other regional fisheries management organizations, especially in the northern IOR. Bay of Bengal does not have any, so there is a need for us to address these gaps. We also need to make it, how do you kind of address any violators of the laws and regulations of the RFMO? Because gathering proof can be a big challenge. Now, we could consider ratification of PSP. I mentioned about the port state fishers, and this is something to prevent IUU fishers to come and dump their fish in our coast or in our ports. Legal empowerment. I mentioned about Navy being legally empowered only for three things. One is piracy, the other is fishing by foreign fishing boats in Indian EEZ, and third is some administrative measures under the Merchant Shipping Act 1958. I think there is a need for us to be legally empowered, for the IN to be legally empowered under the SOA Act. Coast Guard is already, but the Indian Navy is not. So next time when an adjustment comes, whether the Navy can legally handle that is the question. There is an unclassed group of friends. A number of people brought out, and I know the Commandant INA brought out as to what changes need to come in keeping with time in the unclassed. There is a group called the unclassed group of friends. In fact, the leader of that, or one who created that, was actually Vietnam. And there are a number of countries that are participants. We are a participant. We are pretty active. That can push all these that we spoke about. Now, and my final point is that be aware of how the rules are exploited. If you know the rules, not only can you follow them, but you can also find some loopholes. Come back to that one slide view on those 5 things which are mentioned where ships can be boarded. One of them was piracy, if you recall. Other was some slave trade and some illegal broadcasting that somebody does. One of them was stateless. If a vessel is not showing a quite often you will find that navies, board vessels claiming to be stateless if they are suspicious of something. Recently, we had a case where one of the navies, one of our dhows in the Middle East, they were carrying some fertilizers, but they claimed that it was stateless. Despite the fact that the crew later told us that all the papers were shown and everything was shown, the flag was there, everything was there. This is a ruse which was used by many to kind of board ships at sea. So with that, I have finished. I will leave it to you all to ask me any questions if you have any. But BMP, very, very thanks. Thank you.
That was a very wholesome presentation, and must have taken a large amount of trainings to find answers to the new lessons that you gave. Now we move on to the last speaker of this session. That's Admiral Rahul Shankar. Rear Admiral Shankar heads the Communications, Space and Network-Centric Operations Division at Naval Headquarters as the Assistant Chief of Naval Staff, Communications, Space and Network-Centric Operations. An alumnus of the 80th course NDA, he was commissioned on 1st July 1992. A navigation and direction specialist. He is a graduate of the Defence Services Staff College, Wellington, the College of Defence Management, Secunderabad, and the Royal College of Defence Studies, UK. His educational qualifications include MSc in Defence and Strategic Studies, an MA in International Security and Strategy, MSc in Nautical Sciences and Tactical Operations, and Master of Management Studies. Leave something for other students in universities of this world, Rahul. Apart from the many appointments as a specialist, he's also been Executive Officer of INS Delhi, by far the best destroyer on this planet. Amongst command assignments, he has captained the Mauritian Coast Guard ship Guardian and iron ships Taragiri and Satpura. Important staff assignments have included Commodore Operations Eastern Naval Command, Commodore Personnel Naval Headquarters, Director Net Assessment at HQ IDS. He has also served as the training commander NAVAC, Ezhimala training team, as this establishment, this center of excellence was called till the INA was commissioned in 2009. And as a training captain at the commissioned Indian Naval Academy. He will speak to us on cooperative MDA, challenges therein, SWOT analysis of the subject. Over to you, Robert.
Thank you, sir, for that very kind introduction. Vice Admiral Puneet Kumar Behel, Commandant INA, Principal INA, Admiral Anup Singh, our moderator for this session, faculty, officers, and future leaders of our Navy. It gives me great pleasure to participate in this 10th edition of the Dilli series CPAR, a seminar, or now as is the webinar, and speak on the topic of cooperative MDA. However, I would be less than honored if I did not admit that it would have given me much greater pleasure had I been there in person with the cadets at INA. I intend to structure my remarks as flashed. So, what is maritime domain awareness? The Indian Navy defines MDA as an all-encompassing term that involves being cognizant of the position and intentions of all actors, whether owned, hostile, or neutral, in all dimensions of a dynamic maritime environment across the areas of interest. The International Maritime Organization, or the IMO, describes MDA as the effective understanding of any activity associated with the maritime environment that could impact upon the security, safety, economy, or environment. And as you can see on the screen, there is a whole lot of activity associated with the maritime environment. Each of these icons is a vessel at sea. And so we need to know which icon is which vessel, what is it doing, and where is it located. The seas are contiguous, interconnected, and span vast expanses of the globe. As you all know, 75% of the Earth's surface is covered by water. The demarcation of maritime areas and jurisdiction over these areas is classified based on the proximity to coastal states. By which I mean, as you can see, EZ is only up to 400 miles from the coast. However, 64% of the ocean surface and a staggering 95% by volume of the oceans is actually beyond jurisdiction of any country. Much of the economic activity that sustains mankind takes place in such areas beyond national jurisdiction. Given the vastness and complexity, the oceans are also misutilized for various illicit maritime activities such as piracy, narco-terrorism, contraband smuggling, and illegal, unreported, and unregulated fishing. Locating these threats in the vast expanse of the world's maritime domain may vary, very often end up like searching for a needle in a haystack. This is further complicated by the fact that nearly all the maritime traffic is multinational in nature. However, there is another layer of complexity, which is resource inadequacy. The comparison of India's and Maldives' land areas to the EEZ shows not all countries have resources required to monitor their own EEZ. Therefore, addressing this broad spectrum of maritime threats which are increasingly transnational and unconventional, necessitates enhanced international collaboration and national coordination among various levels of information sharing, intelligence, operations, and policy agencies. And so, it becomes imperative to adopt a cooperative approach to maritime domain awareness. Let us explore cooperative MDA further. Cooperative MDA encompasses the collective efforts of multiple nations and stakeholders to comprehensively understand maritime activities, threats, and challenges. It involves sharing of information, intelligence, and resources to enhance situational awareness and promote maritime security. Through cooperative MDA, nations collaborate, monitor, and track maritime traffic, identify potential security risks, combat illegal activities such as piracy, smuggling, and illegal fishing, and respond effectively to humanitarian crises or natural disasters occurring at sea. This collaborative approach recognizes that maintaining peace, stability, and the free flow of trade across seas requires joint efforts and coordination among nations. However, synergizing cooperative MDA faces several challenges. The density of traffic, presence of dark vessels, by which I mean vessels voluntarily switching off transmission, along with the severe limitation of resources, both physical and technological, complicate generation of comprehensive MDA. Upon this is the problem of sharing information seamlessly between stakeholders. I will now discuss a few of the identified challenges which need collective resolution by all maritime stakeholders. A vital prerequisite for cooperative MDA is information sharing. Yet, different countries employ varying technological capabilities, making the integration of MDA systems complex. Lack of common information sharing tools among all stakeholders, concerns over data security, and reluctance in data sharing impede seamless information sharing among countries. The Indian Ocean region hosts a significant volume of maritime activity. While a considerable portion of this traffic adheres to recognized international sea lanes, a number of vessels choose alternative routes, making their monitoring an added task. Established regulations from the International Maritime Organization require all vessels over 300 gross tons to be equipped with automatic identification systems, or AIS. Nevertheless, numerous ships opt to deactivate their AIS for various reasons, or, as I said earlier, go dark. This adds complexity to the maritime landscape and raises concerns regarding maritime security and safety. The Indian Ocean region also comprises countries with diverse national interests, leading to varying priorities, competition, and conflicting perspectives. These divergent interests pose challenges to cooperation and information sharing, hindering the development of comprehensive and integrated MDA network. Negotiating the bureaucratic and administrative processes associated with establishing and maintaining cooperative MDA agreements often entails a very time-consuming process. Efficient cooperative MDA depends significantly on trust among participating nations, which can be fragile and is also subject to prevailing geopolitical fluctuations. The problem of effectively monitoring expansive maritime regions presents a significant challenge for cooperative MDA. Gathering data from diverse sources such as radar systems, satellites, automatic identification systems, and other sensors is crucial for MDA. However, integrating and fusing this data in real time to generate a comprehensive and accurate situational picture is a challenge. These technologies also face limitations in terms of coverage, accuracy, data processing, and integration. While cooperative MDA does pose serious challenges, it also provides stakeholders significant advantages. Cooperative MDA helps in identifying illicit maritime activities and provides the opportunity to counter these threats. Sharing of actionable information on vessel movements, intelligence, and law enforcement can improve the effectiveness of operations to counter illegal activity. Cooperative MDA also helps avoid duplication of efforts and resources by allowing different entities to contribute their expertise and assets to address maritime challenges. This leads to more efficient resource allocation and cost savings. Extensive economic activities on expansive maritime areas also implies frequent maritime incidents, accidents, and emergencies. Cooperative MDA facilitates the sharing of real-time information on distress calls, vessel positions, and weather conditions, enabling efficient and coordinated search and rescue operations. This can save lives and ensure a swift response during maritime emergencies. So, to briefly summarize, cooperative MDA is essential to ensure maritime security, address non-traditional threats, counter illegal activities, enhance regional stability, and strengthen search and rescue operations. Collaborative efforts among countries would lead to improved situational awareness, coordination, and response capabilities, benefiting the entire maritime community. Now, for a few recommendations to enhance cooperative MDA. Regular dialogues, confidence building measures, and multilateral forums, when utilized effectively, can foster trust, enhance understanding, and promote cooperation amongst countries. Efforts should be made to strengthen and expand existing structures such as various information fusion centers and regional information sharing networks. These structures can facilitate information sharing, coordination, and capacity building among participating countries. Investments in advanced technology systems, including satellite surveillance, unmanned platforms, and data analytics, can enhance MDA capabilities. Countries should collaborate in research and development of technology such as RF detection and geolocation, artificial intelligence, and machine learning algorithms, so as to improve data analysis and thereby improve interoperability. Capacity building initiatives should be prioritized to enhance technical expertise, operational capabilities, and interoperability of regional maritime security agencies. Training programs, joint exercises, and knowledge sharing platforms can and do play a vital role in this regard. Efficient information sharing mechanisms, including secure data sharing agreements, standardized communication protocols, and common operating procedures should be established. These mechanisms should prioritize interoperability and address concerns related to data security and sovereignty. With this, I have come to the end of my talk, and thank you for your patient hearing.
Admiral, you brought in a new look to MDA, and I would say as you explained in the first few lines, from maritime domain awareness, we should move to maritime domain understanding. And that requires a lot of cooperation and collaborative effort on part of various countries. We have finished with all 4 papers, and now it is time for a Q&A session. So come up with your questions.
Good afternoon to the chair and all the speakers. I, Cadet Dilli from 30th Annual Regular Achiever Squadron. My question, Vice Admiral G. Ashok Kumar is, terrorism from sea and illegal, unreported fishing are eating up our country's economy. Third, in your opinion, is there any direct link between the two factors or are they working independently?
Okay, Admiral Ashok Kumar, please.
So I didn't get the last part of the question. Can you?
So did I miss out, and that's why I handed over the ball to you. I think what she was asking was, is there any relationship between legal and illegal fishing insofar as surveillance is concerned? Is that right?
Sir, request permission to repeat the question, sir.
Yes, please do.
So, terrorism from sea and illegal, unreported fishing are eating up our country's economy. Sir, in your opinion, is there any direct link between the two factors or are they working independently?
Oh,
No, did you say that terrorism from the sea and IUU are adversely affecting our economy, and is there any relationship? What was the last part of the question?
Yes, sir. I meant,
Please.
is there any linkage between the terrorism happening?
What you mean is there a nexus between the two actors? Is that right?
Yes, sir. Exactly, sir.
Okay, good question. Over to you, Admiral Ashok.
No, so this is a very interesting question. There can be linkages. In fact, if you were to look at blue militia, for example, so the blue militia is nothing but fishing boats, kind of optimally manned to gather intelligence and also to push these loopholes in law to the nation's benefit. Now, if you go back to our own 26/11 in 2008 when it happened, the terrorists actually came by a fishing boat. So that they used the Indian fishing boat complicated the issue of even identification by our own naval and coast guard which are in the area. But the fact is this, that there could be a linkage, but I don't think there is a direct linkage. Of course, both of them impact upon our economy. The blue militia, as we are aware, is used for surveillance information as well. In fact, that many countries use, the one's own fishing boats as years of maritime security and coastal security. So that is something which is done. But there can be a linkage between terrorism and, say, IUU fishing insofar as gathering information and passing it on to, say, any terrorist activity that is found to happen.
Thank you, sir.
Just to expand that question, the answer to that question, I think it was a very well put question, because the thought that is coming to your mind and to many other cadets' mind is, what if there is a nexus between terrorists, maritime terrorists, and other non-state actors like gun runners, drug runners, and IUU fishers? Because that can camouflage a lot of the intent, even if they are into IUU fishing, which does not attract such heavy punishments. For your interest, the jury is still out on what happened to a Japanese tanker in 2010. I think the name was M Star, a Japanese oil tanker which was carrying 1 million or 2 million barrels of oil, passing through the Strait of Hormuz, and in the middle of the night it was hit by a missile. Nobody knew what had struck them. Very fortunately, since it was a double-hulled vessel, as per current regulations, the grenade did not explode, and the projectile did not explode, and there was a huge dent on the outer hull. And the ship was then taken into Mina Jabal Ali in the UAE for investigation. Nobody's been able to pinpoint as to who carried out an attack. Was it one of the two countries? One of the two countries at the edge of the Hormuz, or that means some non-state actor for using a safe haven in one of the islands of one of those countries, or was it a fellow, a maritime terrorist who was trying to exercise his intelligence and carry out an exercise to find out what can he do to block the Strait of Hormuz. You all know how much of oil flows through the Strait of Hormuz. 15.5 million barrels of oil per day, and a lot of LNG, and a lot of incoming exports from countries like China and Europe and so on and so forth. So it's a good question and should put our thinking caps on and so forth as maritime security and cooperative maritime security is concerned. Next question.
Good afternoon to the chair and all the speakers. My name is Kirit Anjali Yadav from 38 NOC Regular, and my question is to Rear Admiral Rahul Shankar. Sir, data and information overload can sometimes swamp decision makers. Sir, how are we planning to utilize AI to streamline data management, especially in an operational context?
Over to you, Rahul.
A fantastic question and very, very topical. So in various domains, okay, I'll go back a couple of years, and what happens is that we're getting each of the sensors firstly collects data in its own form. This data has different formats, and like you rightly brought up, so much of data coming in differently in different formats can easily swamp decision makers. So the idea is to fuse data, like I mentioned very briefly during my talk. And this fusion must happen in real time. So this involves first converting data formats. And each type of data also comes with a lot of data latency, different levels of data latency. As a result, not only do you need to convert data formats, we also need software which will be able to integrate data, and when data fusion happens, each element of data must be reflected at the correct point in time. So you could get, for example, AIS information coming at a different rate, maybe radar information coming in at a different rate, satellite imagery coming in at different rates. So all this needs to be fused, and there will be many more types and formats of data. After it is integrated and fused, we need to overlay machine learning algorithms, AI algorithms, which then learn on the job, and then they fine-tune themselves and provide better and better decision-making ability. So it's a long-run process. We are well on our way to make things happen in that regard. And I must take this opportunity to mention that all of you in the auditorium are entering and joining the Navy at just the right time. It's a very exciting time to be in the Navy. So as you grow, you will see us getting better and better at this game. So, a lot of action is happening in this regard, and the future looks quite exciting in terms of managing data.
Thank you,
Thank
sir.
you, Rahul. Next question.
Good afternoon to the chair and all the speakers. I am Cadet Shweta Jayachandran from course 38 NOC regular. My question is to Vice Admiral G. Ashok Kumar. Sir, Indian Navy in particular has been the first responder during any natural disaster in Indian Ocean region. But there is also an opinion that this has not translated into strategic and diplomatic gains. Sir, how do you see India's stance in this regard?
All yours, Ashok.
So this is a very, very interesting question in the sense that quite often the kind of things that am I audible?
Yes, sir.
No, so as I said, this is a very interesting question. A lot of times tend to be the Navy tends to be asked this question as to is there any benefit out of doing all this for countries? You know? So one is that you mentioned about being the first responder. I mean, this is also a geographical reality. If there is a cyclone that hits any of the countries in the near neighborhood, it is just logical that the Indian Navy is the first one to respond to it. You know. Now, similarly, net security provider, there are a number of countries for whom we actually do their exclusive economic zone patrols because the number of non-traditional threats to maritime security are on the rise. And like Admiral Anup Singh said, this nexus which is building up between various kinds of threats with each other. Most drug peddling today happens through some IUU fishing boat or the other and gets passed on to somebody else. In fact, it's become so sophisticated that even merchant ships carry over long distances and pass it on to a fishing boat for them to go and land it on the coast. To prevent these things happening, we do, I mean, the Indian Navy and the Coast Guard does EEZ patrols for our maritime neighbors in our region, in the entire Indian Ocean region actually. Now to see whether there is a benefit to us or not could be a short-sighted view. You know, we must always be at the kind of beck and call for countries which require assistance and be providing it. And trust me, it comes back only as a strategic advantage much later. I can give you a simple example. One of the countries which a cyclone, the TS1 from Cochin was on a deployment in that region, was diverted, went inside, provided the assistance within 2 days of that cyclone hitting. The next lot of foreign ships which came in, naval ships which came in, were something like 12 days later. You know, and defense agreement which was pending for years got just signed in 1 month because that country realized the importance of being in a good relationship with this country. So at the end of the day, everybody does realize. I mean, my take on this is that continue to do the good things. The results may not be immediate. The very fact that it is strategic, that it could be just long term. You know. But let us just continue to be the first responder, the net security provider, be in a position to assist everybody of any requirements that they have, and at some point in time, that is bound to come to us, enhance trust, enhance support, and enhance support at various international fora. All that would be given well into the future.
Thank you, sir.
Good afternoon, the chair, all the speakers. Myself, Cadet Samson C. Saju from the 3rd term. My question to Rear Admiral Rahul Shankar is, Sir, what security measures are being taken to ensure survivability and robustness of our networks?
So if I understood correctly, you're looking at what security measures we are taking for our networks. So these security measures are at various levels. So there is, of course, there is physical security, which you understand very well. So they're kept in secure premises, etc. But what you also need to understand going forward is the ubiquitousness of network and network components. So the network is not just about, let's say, a string of wires going from one place to another. These networks route through various components like routers, like switches and encryption units, which are placed in multiple locations. Then there is also how does the information travel? How does this data travel? It is not only through a physical layer, like I mentioned, through the switches and wires. There is also a transmission component. What happens when our ships go to sea, when our units go to sea, or when our aircraft are flying for surveillance? So each of these components has a layer of security within. Each of these components has encryption algorithms, and it's a very complex. To get to this, it's very complex, and cryptology, cryptography, there are all various various aspects to it. But things which are happening in this domain and which are current, which you would be happy to learn, are first that we are migrating more and more to indigenous components. We have a lot of activity, a lot of firms, indigenous firms, are now completely up to the game, and they are providing us with the material that is required for these networks. We are also looking at quantum random number generation, quantum cryptography, and those kind of layers. So security of networks, like I said, is in brief provided at multiple levels, and that is the only way to go forward. But that is not to say that one can at any given time be future proof, because this is that classic game of the robber and the thief and the police. So you have to keep upping your game and keep upping it very frequently. So that is the way to go. We have to keep casting our gaze at emerging technologies and keep adopting them, keep bringing them in for this very important aspect that you brought to light, that is the security of our networks. Thank you.
Good afternoon to the chair and all the speakers. I am Cadet Karthik Ajuria of 37 NOC Extended. My question for Rear Admiral Rahul Shankar is, Sir, as per latest developments, China is reshaping its military postgraduate system to make its armed forces smarter, including cultivating more technological talent. The new talent development plan, which focuses on fostering military personnel with advanced technology background and combat skills, is part of the massive ongoing reform. Sir, does India also have a similar plan in the pipeline?
Okay, thank you. Very pertinent question. And of course, we did embark on this path several years ago, part of which is, as you see around you, all the cadet entry officers are now at least BTech at INA. And starting from that level, but more importantly, including continuing military education, as officers continue to serve in the Navy at various stages. They, of course, go for various courses, acquire qualifications, and we are looking at a much broader spectrum of qualifications today. It is not only qualifications which are available in service through existing services training institutes. We are also looking at a much larger spectrum of qualifications at institutions outside. We recruit officers for qualifications in India and abroad for long-term durations, as also for a large bouquet of very varied short duration courses. We have a large number of officers who are doing courses through IITs, through the Defense Institute of Armament Technology, the Military Institute of Technology, including fields like data sciences, data analytics, big data analytics, AI, ML, etc. So we keep looking at new qualifications to acquire and then get our officers and sailors skilled in these varied domains. We have networking professionals certified by the best in the industry that are happening. So it is only when we have personnel trained to in these qualifications can then they man our networks, man our systems, and deliver what we need. So we are at it. Thank you.
Thank you, sir.
So we have finished with the
I
questions.
think midshipmen and cadets of today are too eager to kill the Malabar fish on a Friday. Is that still the menu in the Navy? Friday meal? No more questions? Or is there somebody?
We have finished, sir. Thank you, sir.
Oh, is it? All right.
Sir, I just wanted to add.
Yes.
The Friday fish 1 out of 5 is a
Not in India. Not in India. It could be in Shanghai. More than 1 out of 5 there. All right. So I think it is to the credit of the eminencies in this panel, the speakers, that we've finished the session well before time, and I think the trainees got exhausted in asking questions. A few points that I have before we close. Firstly, man is a continental creature. And that is why, other than those who are in white uniform or are sailing in the mercantile marine, people are generally unaware that 70% of planet Earth is composed of water, and that nearly 40% of global GDP and individual state GDP, even for some landlocked states like Austria and Switzerland, 2 examples, and Liechtenstein, 3 examples of those landlocked states or doubly landlocked states which thrive because of trade overseas, despite being landlocked. And therefore, man somehow always feels that everything exists on terra firma, not realizing how important it is to understand the laws of the sea, the problems of transnational crime, and the importance that MDA or MDU, as we just said, has gained. Indian Ocean region, where we live, apart from hosting some of the least developed countries of the world, and that's what raises problems like piracy and other forms of crime like maritime terrorism, drug running, gun running, and so on, has always been called the crucible of transnational crime. You've all heard of the Hash Highway, which runs from the Makran coast right up to the Gulf of Aden. It may have reduced a lot thanks to activities of the navies and collaborative efforts of navies in anti-piracy and as part of combined maritime forces, but it still exists. And it is to ensure that we have some good order and discipline restored in our waters that these conferences, and particularly this session, was very, very important. Remember what happened in the year 2000, which was narrated by two speakers in this session. One, the suicide hit on USS Cole in Aden Harbor. A lot of people in the world say that the watershed event of this world was 9/11. This happened 1 year before 9/11. And a year after 9/11, of course, was MV Limburg. One inside Aden Harbor and the other one just off that. During Admiral Ashok Kumar's paper, he had mentioned that 26 million tons of fish catch is the result of IUU fishing globally. About a decade ago, two think tanks in Europe had assessed that the Chinese catch is at least 3.64 million tons per year of illegal fishing. And a lot more, they admitted, was in areas where they were unable to do any surveillance over there. These obviously included, in that year, 48,000 tons of krill being caught by Chinese fishing vessels, the large ones, in the Antarctica. And it was a very interesting presentation yesterday by midshipmen from INA on the Arctic and the Antarctica. And I think they mentioned something like 100,000 tons of krill being caught these days. Krill is supposed to be an endangered species, and certainly in the Antarctica, to go and harvest fish of that kind. Now, that being the case, we need to join forces with all like-minded nations to educate those who feel they are have-nots, or those who have a lot and yet continue to damage the environment, damage biodiversity, and do things which are totally illegal and not allowed. Admiral Shankar mentioned about maritime domain awareness, and as I said a little while ago, that should now be converted into maritime domain understanding, as he himself said in his preamble. That means we need to not just pinpoint at who, what, where, but now add why. Why is that vessel there? And why is it not moving what AIS or LRIT indicated earlier? That's where the essence of cooperative effort and collaborative initiatives between countries, between international fusion centers lies. It is extremely important to shift parochialism insofar as cooperative and collaborative MDA and MDU are concerned. We will have to finally come, and finally, hopefully very quickly come to standardized and common protocols for communications, for softwares dealing with the network-centric hardware, and start passing information in real time so that some action can be taken in time as a preventive measure. The best way to do this, insofar as IFCs are concerned, are horizontal linkages between multilateral mechanisms apart from IFCs. For example, IORA, WPNS, IONS, why can't they talk to each other with horizontal linkages with nodes, whether in Seychelles or Madagascar, or even in the Mediterranean, somewhere in Italy, and our own IFC IORA. When it comes to the law of armed conflict and the San Remo manual, Captain Raghavendra Mishra so comprehensively detailed the laws that apply to everyone on the water as well, ever since the San Remo manual dealing with conflict at sea came out. Do you realize that not only us, but many advanced navies also um, give second-rate treatment after having learnt it during their training. It is so important to ensure that every person in white uniform understands what are his responsibilities and what particularly are responsibilities of the command amongst commanding officers, insofar as law of armed conflict is concerned. Not just the Geneva laws, not just the Hague laws, but a complete understanding of everything that is laid out. And that really means that you should let us take the what was the name of that Italian vessel? Enrica Lexi.
Yes, sir, Enrica Lexi.
Let us take that example. What did those two Marines do? The Italian Marines. They just opened fire without determining, even in their own mind, apart from the responsibility of the master in having authorized shooting at sight blindly. They should have seen, is there hostile intent? That is what makes us suffer. Is there need for reciprocity? There was nothing. There was no initiative from the fishermen. It was not charging at the merchant ship. In any case, it was incapable of charging at the merchant ship because it was doing just about 10 or 12 knots. Did they see with their binoculars? Were they carrying any guns? No. If it was a suicide mission, then it should be charging at very high speed towards the merchant ship's hull. Nothing of that sort was right. And the same thing applies in conflicts and wars. So these are very important laws which each one of us need to understand and go through time and again. Going back to IUU fishing, I'm reminded of an incident in 2015 or 16 in the Argentine EEZ, where a Chinese distant fleet vessel was catching fish in the middle of the EEZ, the Argentine EEZ. And when the Coast Guard vessel warned it to stop, instead of stopping, it switched off its navigation lights and started charging away. When the Coast Guard vessel approached it at high speed, it actually turned around and tried to ram into the Argentine Coast Guard vessel. That's where warning shots were fired first in the air. And when that vessel did not behave, then shots were fired on its hull. The vessel sank. I have always maintained that country understands the taste of its own medicine. So I'm saying it very bluntly that something similar was done by the famous Indonesian lady minister of fisheries. Then she blasted a few vessels that had been arrested, having illegally fished in the Natuna Island waters a couple of years ago. So it was great to see all the speakers in full flow in giving very presenting very expansive papers, which gave us a very, very concentrated dose on all things. Lastly, I just want to remind the midshipmen and cadets in the audience, do you know that India has the second largest peninsula in the world at 2.2 million square kilometers. And we also have a proportionately large EEZ. We are fortunate to have seas on the three sides, and the only obstructions, if at all you need to call them obstructions, the only opposing states, as UNCLOS says, either you have adjacent states or opposing states. So opposing doesn't mean that they are opposing you. Are Sri Lanka, friends Sri Lanka and Maldives. They eat away very little. So we are fortunate to have such a large EEZ. And another issue that you need to remember that we are blessed with island territories, particularly the Andaman and Nicobar Islands, which give us 1/3 of our ease, 660,000 square kilometers. These are assets that we need to remember and we need to feel blessed. Thank you very much. All I would like to say now is to thank all the eminent speakers and particularly the National Maritime Security Coordinator and the Commandant of the INA who were present to give their presentations, apart from Admiral Rahul Shankar and my friend Captain Raghavendra Mishra, who's been a shipmate. So has Captain Admiral Ashok Kumar been. Thank you very much. Over to the Commandant.
Thank you, sir. On behalf of Indian Naval Academy, before we sign off, I must take this opportunity to thank the chair for very informed and incisive comments, and also for very, very comprehensive presentations made by Admiral Ashok Kumar, Admiral Rahul Shankar, and Captain Raghavendra Mishra. So before we log off, I would request everyone in our customary manner to please rise and give a round of applause to the chair and the speakers.
Thank you.
Thank you, sir. You may kindly log off at your convenience.
I am sure that this intense and informative session has whetted the audience's appetite. And it is only appropriate that we now break for lunch. I would advise you to keep it light since we have an enriching and an exciting session on the other side. The afternoon session will resume at 1415 hours.